Hello?
Good afternoon to everyone.
Good afternoon. Has the second resource person joined? Priyanka ma'am, has the second resource person has joined?
No, she's joining.
Huh.
Yeah, she's joining.
Just write in the group that all the participants for session 2 may join the meeting because we have little time constraints over the session. Okay,
Right.
just write in the group, participant
Yeah,
group.
sure. Can I please be made the host or the co-host?
Ma'am, actually, if we'll give you the co-host, then our live session will be stopped.
Okay, all right.
So you have been given the access. You can unmute and speak.
All right.
Okay.
Priyanka,
Yes, ma'am.
these 15 participants are there, I think.
Yes, ma'am. We have a total of 15 participants. Some
So-
of them have joined and some are joining.
All of them have joined?
No, ma'am, they're joining. We are starting at 1. We have 5 more minutes. We'll start.
Okay.
Okay.
Priyanka ma'am, first, I would request you to kindly take an attendance so that you will know who are there, and those who are not there, we'll at the end we'll put their presentations.
Yes, right.
So we'll positively start at 1 p.m. Okay. The participants are requested, until unless it is not required, to unmute yourselves. Please be muted so that there is no difficulty for the person who's presenting the paper.
Do we have the second presenters? Alur Raja Rajeshwari Sautanya and Bhargavi Mannava?
Yes, ma'am, I'm
I'm not
here.
able to see. Yeah, okay, all right.
Right.
Shall we start?
Yes, ma'am, you can proceed with the session.
All right, thank you. A very good afternoon to the respected dignitaries, esteemed presenters, participants, and delegates of this conference. I, Priyanka Majumdar, who can help now. At the outset, I would like to welcome our learned dignitaries, resource persons who will be chairing this technical session. Dr. Aprajita Barua, ma'am, Head, PG Department of Law, Guwahati University, and Mr. M. Sir.
Ma'am, there is some
In this session,
bandwidth
we
problem.
have
Ma'am, there is some bandwidth problem with you. I'll just start with the session. Priyanka ma'am, please mute yourself.
Is it internet issue? Because
Yeah. So I'll just start with the session.
actually it's not audible.
Yeah. So a very warm welcome to everyone present here today. For the technical session 2, we have with us as resource person Dr. Aprajita Barua ma'am. She is the head of the Department of Law, Guwahati University, and with us we have the second resource person we have with us is Mr. Atul Sahi, Advocate, Allahabad High Court. So for our first presentation, we have Shivani Datta, assistant professor. She will be speaking on the topic, the aftermath of CAA, the path of the stateless.
सेमिनार है अभी 1 घंटा नेशनल सेमिनार
Good afternoon. I hope I'm audible.
Yes.
1
Yeah.
घंटा
First of all, good afternoon to the
Seminar.
chairperson. I'm Shivani Datta. I'm an assistant professor at the Anand Sagar University, Bangalore, and I'm pursuing my PhD from NLSIU, Bangalore. So as the time slot is very short, I would just sum up what I intend to write in my paper. So as the topic says, the aftermath of CAA, a path to statelessness, which I am referring to particularly to the state of Assam. Because when CAA or Citizenship Amendment Act 2019 was brought into place, what has affected is with respect to, apart from the other parts of India, majorly it has affected the state of Assam. Because if we look back into the history, or if we look back a little before what was going on, or the ongoing process, it was with respect to the problem of illegal immigration from the state of Bangladesh, from the country of Bangladesh to the state of Assam. So where there was an Assam Accord which was signed, where it was necessary, it was agreed that we will work for the identification of the alleged illegal migrants, and for that purpose, in the state of Assam, there are numerous, approximately 100 foreigners tribunals which are established. However, with respect to the foreigners tribunal, the process or the members, or how it is going, it is a different thing, which I'll be definitely covering in my paper with respect to the critical analysis of the foreigners tribunals. Apart from that, if we see, before the CAA, there was a National Register of Citizens, which was only updated in the state of Assam, where the people of Assam have to produce a document to prove their citizenship. So here, when we look at from the constitutional perspective, we can see that we have moved from the concept of citizenship by birth to now citizenship by descent. So that has considerably changed, and there is a particular year which we need to show that we have been there, or we have our ancestors or descendants, we are descendants of our ancestors from that particular day. And if we fail to produce that, we are considered as non-citizens. So when we say non-citizens, apparently the Foreigners Act should have been in place. But what happens in this case is that they are completely considered as without any rights. So they're considered that they are non-citizen, they are devoid of any rights, they are put into the detention centers. With respect to the CAA, what now they have done is that the foreigners tribunals have determined that there are certain persons who are considered as illegal migrants. They have determined it. They have given their opinions. However, now, even after the opinions being given by the foreigners tribunal, there are certain category of people which fall into those minority categories from the country of Afghanistan, Bangladesh, and Pakistan. They are now eligible to acquire citizenship. So here, there are two things which we need to focus is that, first thing is that we are depriving a category from taking citizenship. It is a very welcoming approach that we are offering citizenship. We are to certain group, but it cannot violate the principles which is there in the Constitution, such as Article 14 and 15 of the Constitution. So my paper, basically, I argue with respect to how the division, or how it has come to the decision of giving citizenship to a certain category of person belonging to certain communities and depriving of to the others. That is one thing which I need to, which I will highlight. And secondly, by doing that, we are putting a group of people to a situation where they are considered stateless, because there is, on record, there is no proof that they belong to any other country. So this is basically my paper aims to, give the information.
Thank you, ma'am.
Thank you.
Am I audible?
Yeah.
Okay. Thank you very much for presentation, ma'am. Insights from the resource persons towards the end of the session.
Sure.
So all right. We'll move on to the next presenter. We have Sangeeta Das and Ume Safia Begum as our next presenters in presenting on the topic exploring environmental or climate justice with reference to the weaker sections of the society. I'd like to inform all the participants that you are allotted 5 minutes time to present your paper. At the conclusion of the 3 minutes, I'll send a reminder and we request to conclude within the next 2 minutes. So we can have the next presentation. Thank you.
Am I audible, ma'am?
Yes, you are audible.
Very good afternoon, respected ma'ams and sir. I am Sangeeta Das, going to present our paper titled The Environmental and Climate Justice with reference to the weaker section of the society. And here I am going to share some slides.
Yes, we can listen you.
Okay, ma'am. Climate change. In the first slide, sorry for inconvenience.
You have to share this.
Yes, ma'am. Yes, ma'am. Okay.
Show the first one.
Okay, ma'am. Yes, ma'am. And my paper title is Exploring Environmental or Climate Justice with reference to the weaker section of the society. And in the first slide, I mentioned the important topics of this my research paper. And in second slide, I give definition of climate justice. Climate change is a global emergency and one of the biggest threat to human development. The effects of climate change are being felt around the world, but the impacts of climate change are not evenly distributed. The people who have contributed the least to global greenhouse gas emissions are often hit by the effects of climate change. Climate justice means linking human rights with development and climate change. Climate justice, in short, climate justice is about addressing inequities in the fight against climate change. And it also addresses a broad range of social, racial, and environmental injustices. And in the next slide, the groups vulnerable to climate change: women, children, persons living in poverty, members of indigenous populations, and socially marginalized individuals are mostly affected by the climate change. And human rights dimension of climate change. The concept of human rights in general emerged after the Second World War, but the right to healthy environment was never a priority before the Stockholm Declaration. Climate-related hazards, including greater changes and extreme weather events, and directly affect people's livelihood. It causes threat to human health. And the major health impacts include greater risk of injury, disease, death due to the more intense heat waves and fires. In this year, the biggest fire has broken out in the forest of Canada between May and July. By August, nearly 14 million hectares had already burned. At least 7 people died as a result of the fires. Climate justice and international development. International climate justice recognizes that climate change cannot be simply categorized as an environmental problem. Rather, it is a challenge which closely related with socio-economic systems. The right to clean environment is rooted in the Stockholm Declaration. The another declaration on the environment and development was the Rio Declaration. The United Nations Conventions on Climate was the product of this declaration. The main objective of this convention is to stabilize greenhouse gas concentration in the atmosphere at a level that will prevent the dangerous effect within a time. Another step towards advancing the climate justice was taken in Third Conference of Parties in 1997 with the adoption of Kyoto Protocol. But this protocol was replaced by the Paris Agreement. The Paris Agreement provides a framework for all countries to take steps to curb curb climate change. It aims to reduce global greenhouse gas emissions and limit global warming. This agreement serves on the core point of ongoing global negotiation on climate change. India's initiatives for climate change. India launched National Action Plan on Climate Change in June 2008. There are 8 national missions in total which form the core of the National Action Plan. Some of them are National Solar Mission, which main objective is to establishing India as a global leader in solar energy. The National Water Mission, this mission was launched in 2011, and the purposes of this mission is to conserve water. Another mission is National Mission for Green India, makes plans to tackle the challenges caused by climate change, works towards reducing deforestation, enhancing private-public partnership for plantations. On the other hand, currently, the country spends 3% of GDP on adaptation, and National Adaptation Fund was established and is operated under the Ministry of Environment, Forest and Climate Change. And the last, the conclusion part here, the climate justice is a strong medium which can be used against the injustice that particular group witnesses. It can be used to awaken the society towards the impact and issue of climate change. In order to achieve climate justice, an approach is required, and there is a need for cumulative changes. Yes, ma'am. Need to look beyond national boundaries to what is good for humanity as a whole. Concluding by saying that immediate action should be taken by all the countries before it's too late. Thank you, ma'am.
Tejas Deep Kharka, we request you to please mute yourself. Thank you. Okay, Sangeeta, have you concluded with your presentation?
What, ma'am?
Have you concluded with your presentation?
Yes, ma'am. Yes.
Okay.
Awesome.
Thank you so much.
Yes, ma'am. Thank you.
We'll now move on to the next presenters. Allu Raja, Rajeshwari Saujanya, and Bhargavi Manava will be presenting on the topic, the purpose which the climate justice serves.
First of all, I would like to make sure whether I am audible and visible.
Yes, you are audible and visible.
Well, my name is Rajeshwari Saujanya. I am a final year law student pursuing law at KL University. And I'm feeling so honored and privileged to present this national paper before you all. Well, the title of our paper is The Purpose Which the Climate Justice Serves. First of all, in this paper, we have included the significance of climate justice that act a pivotal role in protecting the environment. And climate justice isn't about the climate justice, like isn't it just about the term climate, but there are so many things that are involved, that there are so many things that come under the meaning of climate justice, such as it also includes about the natural resources, it also includes about the ozone layer, it also includes about all the things that are part of the nature. And also we have environmental laws that impose punishments to the people who are doing hazardous activities and who are destructing the nature in an immense manner, but we are only focusing on the imposition of punishments to them, but we are not raising an awareness and we are not creating a responsibility amongst the people which they have towards the climate justice. In our country, the concept of climate justice has no importance compared to the other laws which we are having now, such as the Indian Penal Code or the Criminal Procedure Code. Most of the cases are regarding these subject matters, but there are only a few case laws that signifies the importance of environmental protection, and there's no scope of climate justice. There is the introduction of climate justice, but most people aren't aware about this. So we have covered all the reasons. We have covered about the definitions that are given by the famous environmentalist, and we have included the impact of what would happen if this climate justice is ignored. And we have also raised a few questions in the paper, and we have mentioned about the climate justice and the questions that are regarding those in an accurate manner, and about the involvement of our countries and what measures are being taken by us regarding this climate justice. So this is about our paper. Thank you.
Thank you, Saujanya Rajeshwari, for making a very brief and concise presentation on your topic.
Thank you.
Thank you for your participation. We'll now move on to the next presenter. As we do so, I request the resource persons to note down if they have any comments or feedback or insights for the presenters, which they can speak about after we have concluded all the presentations. Our next presenters are Dr. Upankar Chutia and Dr. Gyaneshri Datta, who will be presenting on the topic assessing the legal framework for the climate refugees in Assam, need of the hour. I invite both of them to start with the presentation.
Thank you so much, ma'am, for such a warm welcome. I, Dr. Gyaneshri, along with my co-presenter, Dr. Upankar Chutia, will be presenting today on the topic assessing the legal framework for climate refugees in Assam, the need of the hour. Madam, I hope we are audible. I am audible to you as well as visible. Am I audible and visible, madam?
Yes, you are audible.
Thank you, sir. Thank you, sir. So since the time allotted to us is very less, we'd like to focus on the crux of today's paper. That is a central issue. That is a research problem, which I think is very, very important for us to focus upon. Today, the beautiful northeastern state of Assam, which is situated in India, is having devastating effects due to the climate change migrants or the environmental migrants in one way or the other. And this upcoming years, we are seeing that due to certain floods coming in Assam from the river Brahmaputra, or flood or earthquake or cyclones, and which are the various aspects today being seen due to climate change, the entire climate refugees are being affected to a very huge extent. And if we focus on the legal issue today, no doubt, we have a plethora of laws. I mean to say the national laws as well as the international laws, starting from the UNFCCC, that is the United Nations Framework on Climate Change. We have the Kyoto Protocol, we have the Paris Agreement of 2015, we have the Assam Accord, we have the 1967 Refugee Convention, which is from the international aspect again. But the very question which comes today is, do we have any comprehensive sui generis law in this regard? No. This is a matter of huge discussion today, which can protect the rights as well as obligations and the duties of the interstate migrant, of this climate change workers, the laborers, right? And the next of the discussion will be presented by my co-author, Dr.
Dr. Gyaneshri, just a moment.
Ma'am, I think there is some voice.
There is some background noise.
Could you please mute yourself? Amrita Singh.
Request all the participants, please unmute yourselves.
Yeah, thank
Mute
you,
madam.
yourselves
So without-
mute yourselves so that
Yes.
the presenter is not having any difficulties in presentation, because everybody will get a chance. So one should not disturb the presenting person.
Sir, I hope we get an extra of 1 minute, because one half a
Yeah,
second
yeah,
is
definitely,
almost.
definitely,
Thank you so
definitely.
much.
Thank you.
So without wasting much of our time, since in India we don't have any sui generis comprehensive law, which is the need of the hour, we need a law which will actually protect the rights and the obligations of these climate change migrants or and most of these migrants today are found in places like Dhemaji, Bongaigaon, Kaziranga National Park, etc., etc. But we don't have any law which protect them from such displacements. And the rest of the points will be focused by my co-author, by my co-presenter, Dr. Upankar. Over to you, sir.
Thank you, ma'am. Hi, everyone. This is Dr. Upankar again. So I will be talking about the impacts of climate change in Assam. As my slide shows that we are not unaware of what's happening with regard to the impacts of the climate change. For example, floods, river erosions, then changes in biodiversity, what we have seen earlier, is completely changed, all due to flood and soil erosion. Many people are being displaced to a greater extent. They have lost their livelihood. Their cultural heritage are being said. If you remember the previous slides where we showed many people traveling from one place to other because they don't have any place to live in or practice the agricultural arena. So here the climate change has been created a great impact in among the people in Assam. But as ma'am has rightly pointed out that there is no any mention even in Kyoto Protocol or any other protocol, EMNFCC, there is no direct definition of this thing, climate change refugee. Okay, so here in our paper we will talk about the identification of definition and how this climate change has been impacting. So there are many other challenges with regard to the legal framework. For example, as I said, definition. Then second is responsibility and liability. Who will take the responsibility? For example, we have seen in various news that flood impacted people will be given this much of amount, but there is no stratified law. And as there is no system of burden sharing, because one state's flood may affect the people of other people. So the burden sharing problem is a bigger problem here. For example, floods from West Bengal coming to Assam, affecting Assam, or vice versa, that might really affect the people at large. But as there is no law, all these policies could not be made. So there needs to be an institutional coordination for the same. Over to Dr. Gyansri for conclusion and suggestions.
Thank you, sir. So coming to the suggestions which are from our side, we need a thorough legal framework which will be specifically designed to accommodate the requirements and the various difficulties being faced by these refugees. There must be strong coordination between the lawmakers, between the stakeholders, between the policymakers, without any biasness, and no political motive should be there. And most importantly, we should have a strict comprehensive definition of the word specifically for climate change refugees or migrants of Assam. And I think if this is done, and then only, and if a sui generis law is being brought into the picture, then only the beautiful northeastern state of Assam will be protected, and our heritage, our culture will be protected to such a greater extent, who will actually look for the sustainable development for the future as well as for the present generations. This is all from our side. Thank you so much.
Thank you, panel.
Thank you, panel.
Thank you, Dr. Upankar and Dr. Gyanashree, for presenting on a very relevant topic.
Thank you, madam. Yes.
Thank you once again. We move on to our next presenter, Mridusmita Barua, Teaching Associate, who will be presenting on the topic, Role of International Human Rights in Combating Adverse Effects of Climate Change. I request Mridusmita Barua to kindly start with the presentation.
Am I audible?
Yes, you're audible.
Good afternoon, respected dignitary, resource person, Dr. Aparajita Barua ma'am, Ms. Priyanka Majumdar ma'am, and also from the Gulati Law Office. My paper is focused on the issue of interrelationship between international human rights law and the effects of climate change. Firstly, I would like to address the legal and operational challenges that are encountered in adoption of a human rights-based approach to climate change under international law. Climate change, as we already have witnessed, is an urgent global problem that requires immediate action. Factors like rise in sea level, which has ultimately caused flood, population displacement, salinization of fresh water, and loss of cultivable land, and also increase in the weather, temperature, variation, changes in the coastline, melting of the permafrost, polar ice caps and glaciers, all we have witnessed in the history that are the major effects of climate change. But my topic that I would like to delegate is the interrelationship, how the international human rights law has played a pivotal role in combating the adverse effects of climate change. The human rights relationship with climate change can be traced to the well-established body of literature connecting human rights and the environment with an effort to establish a free, a safe, and a healthy environment. The varied consequences of rapidly increasing climate change are having a very negative impact on the marginalized population all over the world, reinforcing the existing vulnerabilities and deepening inequalities. The vulnerable population has been impacted by the disastrous consequences that climate changes has done, and also as the statement given by former UN Deputy High Commissioner for Human Rights, Flavia Panseri, she has stated that the countries who have least contributed to the emission of greenhouse gases in the atmosphere are the ones who share a greater number of burden. Likewise, the application of human rights law to the climate crisis is not without criticism. It has often been argued that the domain of human rights law is ill suited to addressing the global climatic changes, like the cases of identification of the victims of human rights violation associated with climate changes. The Landmark Convention on Climate Change, like UNFCCC, Kyoto Protocol 1997, the COP21 Paris Conference, as well as the Glasgow Climate Pact, their enforcement regarding human rights obligation has been limited and framed in terms of soft law guidance. There has been an absence of a binding human rights provision to offer the remedies to the affected displaced population, which has highlighted the need to integrate international human rights law to provide a better recourse to the climate vulnerable states, groups, and population. And also the recent appointment of Ian Fry as a special rapporteur of the promotion and protection of human rights in the context of climate change has been an evidence that there has been a growing alignment and recognition between these two fields of international law, that is the human rights and international environmental law. The preambulatory clause in the Paris Agreement COP21 has referred to the need for the state parties to promote, respect, and consider human rights in taking climate action. And this is indicative of the fact of the growing recognition in the international discourse that between the relationship between climate change regime and human rights protection. As there are many suggestions that I would like to make, like building up a climate risk assessment and allocation of human rights capacity building resource to streamline all the existing human rights treaties in compliance with the environmental treaties. Okay, ma'am.
We request you to please conclude your presentation in a minute.
Okay, ma'am. So the challenges that we have encountered here is the exclusivity of international human rights law and climate law, the operational challenges facing human rights treaties, the legal challenges which we have witnessed in the recent decades regarding climate litigation lawsuits, and also the attribution of the state responsibility in addressing the climate crisis with regard to the transboundary climate harm that has severely impacted the vulnerable populations of the world. So by concluding my speech, I would like to refer to a statement given by Mary Robinson, who has been a former High Commissioner for Human Rights and also now the founder of Climate Justice. She has stated that climate change is not only a legal issue, but also a global and ethical issue, and it has to be addressed by an adequate human rights solution. Thank you.
Thank you very much, Smita, for bringing in the human rights dimension to the climate change domain and the challenges in this regard from the international perspective as well. Thank you for your presentation. We move on to our next presenter, Medha Tiwari, research scholar, who will be presenting on the topic social media intermediaries and democratic culture, a legal reflection.
Good afternoon. Am I audible?
Yes, you're audible and visible.
Good afternoon to the resource persons and moderator, ma'am. My name is Medha Tiwari. I'd like to thank the university for giving me the opportunity to present my paper here at this esteemed platform. The title of my research paper is Social Media Intermediaries and Democratic Culture, a Legal Reflection. So my slide or the presentation consists of about 10 slides, and I'd like to precise my entire presentation in about 5 minutes. The abstract of my entire article basically states that the major research problem which I am focusing upon on my research paper is the internet freedom. That is the concept of the freedom that is available on the internet and specifically on the social media intermediaries, that is the social media platforms. The major keywords that I have used in my research paper are social media intermediary, legislative framework, liberty, freedom of expression, and legal reflection. Now I'd like to talk about a basic introductory part of my research paper. It basically talks about the social media intermediaries, which are basically a buzz expression for services carried over the networks. Some common examples of social media intermediaries are WhatsApp, Instagram, Skype, Netflix, Amazon Hotstar, and YouTube. Basically, the research methodology that I employed while writing this research paper was doctrinal form of research, wherein I used the theoretical material available and the secondary sources of data available. Next, I'd like to talk about the relationship between media and democracy. As we are all aware that democracy is a reflection of freedom to express ourselves freely. Thus, the extent of press freedom is regarded as the parameter or the credential of democracy of a state. That is to say, we can in a way know that what is the level of we can say that what is the level of freedom that is available in our country, or what is the level of democratic principles that are upheld in our country, keeping in mind the freedom of speech and expression, the ambit of freedom of speech and expression in our country. As we are all aware, the pre-independence era of our country was characterized by a lot of not so good experience. That was because we were being led by the colonial experience. But later on, after we received our independence after 1947, from there on, we saw a difference in the rights that were available to the platforms in respect of social media. But talking about the legal outlook towards these social media intermediaries, there are two core ideas from where the entire concept of social media came from. One is preamble and the second is the Article 19(1)(a) of our Indian Constitution. Other than this, because social media intermediary being a concept that has been in use, or the term that is being used very frequently, there have been certain legislations which have talked about these. One of being Section 79 of the IT Blocking Rules 2009, which says that any intermediary shall not be held liable legally or otherwise for any third-party information, data, or communication link available or hosted on its platform. Other than this,
yeah, the 3 minutes are over.
okay.
And I also request Dr. Bandita Sengupta, Chandrit Kaur to please mute themselves. Chandrit Kaur and Dr. Bandita, please mute yourselves.
I proceed, ma'am?
Yeah, you may continue. Dr. Bandita Sengupta and Chandrit Kaur, please mute yourselves.
Ma'am, I'd like to precise it within 2 minutes.
Yeah, please. Thank you.
I was talking about the legal outlook. So the recent advancement in terms of the IT intermediary guidelines and digital social media ethics code, which came in the year 2021, but there have been significant advancements in the year 2023 as well. In the year 2021, we were discussing about the entire framework which is going to regulate the social media intermediaries, whereas the rules that have come in 2023, they are talking about bringing within their ambit the online gaming platforms as well. As ma'am has pointed out, there is very less time left for my presentation. I'd like to just briefly tell the major challenges that are faced by the social media intermediaries. There are 4 basic challenges that I've covered in my research paper. One being the data privacy. Next is content moderation. Third is fake news. And the last and the most prominent one, that is cyberbullying. Next, I'd like to talk about a few suggestions that I've given in my paper. One being transparency. The second being multi-stakeholder governance. Next is user empowerment. Fourth suggestion is ethical content moderation. That is, the content that is being moderated needs to be moderated in an ethical manner. Next is data privacy. And the last is media literacy, that is litigating, making people aware about what the rights of media are. Lastly, I'd like to conclude that there is a need to balance out between the rights of the social media intermediaries and the rights of the governing platforms. Thank you. I'd like to conclude now. Thank you, ma'am.
Very much. Thank you very much, Medha, for your presentation. It is definitely cannot be denied that social media intermediaries do play a major role in the context of a lot of legal issues that we have in today's technologically advanced world. So thank you for your presentation, highlighting the challenges in this regard and the suggestions as well.
Thank you, ma'am.
I would like to call upon Gopika S. Nair, a student who is presenting on the topic of critical analysis of climate justice from an Indian perspective. I'm not able to find Gopika in the participants list, so if you've joined by a different name, please let us know. Gopika S. Nair. Okay, we'll move on to the next presentation. Do we have Biswadeep Datta in this session?
Yes, ma'am.
Thank you, sir. Biswadeep Datta, research scholar, will be presenting on the topic of comparative analysis of SEBI insider trading regulations as per Indian regulatory regime vis-a-vis UK and USA. Thank you, sir.
So my paper title has been basically having a critical analysis that to a comparative approach of the USA UK regulation and a kind of a very critical analysis of the SEBI regulation with the 1995 amendment and including the 2015 regulation. So if you put the new short of 2020 amendments, the many electronic evidences and those measures have been included. So if we see the recent consultations paper that's been proposed by the SEBI, their most approach was to include the very kind of a critical investigation stages. Previously, what we have done, we have derived the section 10 clause B, subclause 5 of the SEC regulations from the USA, where they have provided a very critical analysis. What would be the very investigation stage? So first would be we have to file a criminal cases against the appellant. Based on that, the civil petition and the criminal appeals would be right. So if you go to the USA and UK regulation, they have a different approach over it. First, there would be a civil action and then there would be the criminal action. For the civil action, foremost thing is that the penalty is not a kind of there is no kind of a limitation of the penalty. So it can exceed to the amount whatever has been kind of done during the person who has been involved in insider trading. And if you see the criminal actions, they have been put imprisonment for till life imprisonment. But in the Indian regulation, if you see, as per the SEBI Act 15B, they have put a kind of a penalty clause. It should extend not less than 15 crore, and it should be 4 times more to the total capital amount cost, the total punishment or total kind of a criminal like fraud has been happened, fraudulent activity has been happening. So in my paper, one critical suggestion that I want to put, recently this previous month only, the May 2023, the SEBI has put a kind of proposal to us to include the arbitration, conciliation, and negotiation processes for the SEBI insider trading regulations also. And it would be better as the foremost thing of the SEBI is to protect the investors and protect the integrity of the capital markets. So right now, if you see the regulation as per the Indian context, we require more manpower, more sophisticated equipments have to be needed, more collaboration from the private entities and also from the government bodies is required. And there is also kind of a like transfer of learning and share is required from all the international regulators. So if it would be possible so that the SEC would be guiding the SEBI and SEBI would be also helping the SEC in that part. Also, right now, if you see that the term cybercrime has been more coming integral part with the insider trading problem, because the electronic evidence is not defined anywhere in the insider trading. So we can't tell it if it's a fraud or not. If we collect any sort of evidence, then only we will be able to determine whether there is whether that person who's been connecting to that kind of a UPSR, like unpublished, price-sensitive information, whether there is a direct link. And if you think about any of the theories as such, there is only the governing three principles. One is the classical theory, where it will be based on whether the person who is within the management of the company or any person who is connecting to that information is involved. And the second theory, misappropriation theory. So whether if you're dealing that information in the trade market, you should reveal it. Or if
Mr.
you're not,
Biswadeep,
yes, yes.
3 minutes are up. This is just for your information.
Yeah, I'm done with 1 minute. So lastly, what I'm going to conclude is that based on these three principles, classical theory, misappropriation theory, and property right theory, the more holistic approach is required on the part of the investor. So investors should be given a bench whether they want to take that matter before the court or before the SEBI. Thank you.
Thank you very much. Indeed, connecting about electronic evidence in the context of insider trading and talking about the need for the transfer of learning and sharing, and as well as collaboration with private entities. Yes, I think we have a lot of food for thought in this regard. Thank you, sir, for your presentation. We now request Dr. Vandita Sengupta, academician, to present on the topic Education and Tribal People in India, a Social Legal Analysis.
Good afternoon, on and all present here. Today I'm going to present my topic on education and tribal people in India, a socio-legal analysis. Now, as we all know that education is one of the indispensable element for the enlargement of the egalitarian society. So tribal people, the tribal community are also not away or not, they are also circumscribed in this prospect. Now, tribal people in the British India generally targeted because in India, most of the tribal community are dispersely situated in various parts of India. Now, tribal people, they are getting special privileges nowadays, but it is, if we go to the look back to the history, then what we find that in British India also, as well as in our contemporary India, we are now having various laws, regulations, and policies taken for the development of this vulnerable group because they are socially and economically underdeveloped. And in this respect, if we consider the educational policy of the 1986 and similarly the educational policy recently developed, that is the 2020 educational policy, various initiative has been taken by the government of India. Now, prior to the just immediate to the independence, our then Prime Minister Jawaharlal Nehru, he considered the aboriginals or the indigenous people and or the people who are living in the forest areas or hill areas, they are also the integral part of our society. And focusing on that, various constitutional provisions were being framed in this respect. Similarly, the Article 15, 16, 4, 19, 5, 21A, 23, 29, 2, 39, 45, 333, 330, 332, 335. Not only the constitutional provision, now setting out various schools like Ecolab Residential School, Jawahar Navodaya Vidyalaya, these kind of initiatives were taken for their upliftment and for to bring them in the mainstream of the society. But challenges are huge. They are being faced by the tribal children in their during their school hours. Now, what are the basic challenges? Basically, they are psychological, the psychological element, that is they are disintegrated from the mainstream of their society. Now, mother tongue, language in the mother tongue is also a challenge for them because most of the schools are being, if they are residential also, basically the official language are Hindi and English. In that respect, definitely they found huge challenges in that respect. So the challenges not only to be underlined, but also some suggestion in that respect I have to put before the panel, that is the using both mother tongue and the official language of that concerned state should be taken into consideration. Then certain relevant ancillary learning material, that means they should be technologically equipped, they should be technically literate. For nowadays everyone is very much dependent on the technology based tools and learning also, so technologically they should be literated. Now then the folk literature, focusing on the folk literature, that basically the indigenous folklore or the folk culture, because they are also having, if these things are not associated in our mainstream of educational policy, then definitely they will remain disintegrated from the mainstream of our society. Then instigating pecuniary help, though various scholarships are still available for the scheduled tribe people who are meritorious, but more initiative will be taken into that respect, then definitely they will be considered themselves with the mainstream of our society. Thank you, ma'am. Hello.
Thank you, Dr. Yeah, thank you, Dr. Bandita, for your presentation with regard focusing onto the marginalized communities and their rights to education and tribal people. Thank you for your presentation in this
Thank you,
regard. We would now like to call upon our next presenter, Chanpreet Kaur, academician, who will be presenting on the topic, understanding the synergy between the right to bodily integrity and reproductive rights of women.
Good afternoon, ma'am. Thank you so much for the introduction. So today on the two-day virtual National Conference on Emerging Contours of Law and Justice in Contemporary Era, I would like to speak on the topic, understanding the synergy between the right to bodily integrity and reproductive rights of women. So this is actually a very interesting concept and very relevant today because it discusses two important topics, which are first of all the right to bodily integrity and second of all reproductive rights. So first of all, starting off with what is the right to bodily integrity? So right to bodily integrity means the right to control oneself or the right to control one's being. It means the ability to have independence and take independent decisions pertaining to your body and yourself. So nowadays, this has a lot of prevalence because not only women have the right to bodily integrity, but also men and other communities like the LGBTQIA community, their right to bodily integrity is also being identified across circles. So the right to bodily integrity actually started off as a way of protecting a person against torture, that a person should not be subjected to torture. And therefore, this was related to almost like the World War rights, where at that time people were being subjected to a lot of torture during the Hitler regime and of course, across the world. So it slowly moved on to women's rights, where women's bodies were being controlled by the state. So what happened there was that women were not getting the right to have a say in their own bodies. This is intrinsically linked to the concept of the right to abortion. So right to abortion, as we know, is not a proper right in all countries. Even USA, where it is seen that it's considered to be a very progressive democracy, but still there the right to abortion, which is an integral part of reproductive rights, gets curtailed a lot. So there the whole discussion about this right is pertaining to pro-choice and pro-life. So this started off from the concept of Roe versus Wade, the case in which this right was discussed and is still discussed in the US. So in Roe versus Wade, the right of a woman to seek abortion was recognized, and it was stated that if a woman does not go through with that abortion, it may have an impact on both her physical self as well as her mental self. So therefore, that mental self concept is directly related to bodily integrity, that I should be allowed to do what I want to do with myself. If I want to go through an abortion, that should be allowed as well. So this concept started off from that time, and that debate is going on till now. Now, as far as other communities are concerned, for example, the LGBT community, where nowadays we are seeing so many transsexuals and so many sex change operations happening, where people have started identifying themselves as another gender, which they were earlier not recognized as. So that also is sometimes problematic because some countries may recognize that while other countries may not recognize that right. So generally, reproductive rights and relating it to the concept of bodily integrity actually stems from...
Chanpreet?
Yes, ma'am.
Yeah, you have 2 more minutes.
Yes, ma'am. Yes, ma'am. So it actually started off from this philosophy given by Martha Nussbaum. So she wrote an article on human rights capabilities, or some rights which have to be given to people in order to enjoy their life fully. Right to bodily integrity was one of them. And nowadays, its relevance to reproductive rights is that firstly, people should have the right to decide that whether they want to start a family or not. Secondly, it includes the right to go through an abortion. Third, it also includes surrogacy rights, because this is a hot topic in India since surrogacy was has been struck down through the act that came out. So therefore, women should also be able to go through the concept of surrogacy if they decide so for their own body. So therefore, this together, actually, if we give this right to bodily integrity, it protects not only this particular right, but it is directly related to other rights, such as the right to privacy, the right to life, and of course, the right to freedom, right? And personal liberty. So therefore, this right should be promised. As such, it is a part of various international conventions and laws, but probably there should be more discourse on it so that it is actually made a reality with relation to many laws. So thank you so much. I would like to wind up my presentation here. Thank you so much, Priyanka ma'am. Thank you.
Thank you, Chandpet Kaur, for presenting again on another relevant topic of bodily integrity and with regard to right to adoption. So yeah, pro-life and pro-choice, the debate still stands. So thank you very much for enlightening the participants on this issue. I would now like to call upon our next presenters, Najima Begum and Alka Patel, students, who will be presenting on the topic constitutional morality and democratic ethics.
Am I audible, ma'am?
Yes, you're audible.
Good afternoon, everyone, honorable dignitaries and everyone present in this session. I, Alka Patel, student of PG Department of Law, Guwahati University. I'll start with a quote. Constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people have yet to learn it. Democracy in India is on a top dressing on Indian soil, which is undemocratic in nature. That quote has given by Dr. B.R. Ambedkar. Constitutional morality and democratic ethos is one of the important aspects which is correlated with each other. Democratic ethos in a country can be strengthened through the regular conduct of the elections and the people's participations for the decision-making process. Constitutional morality involves the commitment to supporting the ideas embedded in the country's constitution. That is the establishment of the rules of the law in the law while interpreting the changing aspirations and ideals of the society, which means to bow down to the norms of the constitutions. And societal morality is one of the important aspects which is related with constitutional morality, that is the values and norms that exist in a society and that rules that govern by the number of the society on how they should behave with each other for their welfare and well-being. This concept was enunciated by British classicist George Grote in 19th century, and he described it as a popular sovereignty with freedom and self-restraint. In India, this concept was reiterated by Dr. B.R. Ambedkar in November 1948 in the Parliamentary Constitutional Assembly debate. Dr. B.R. Ambedkar has defined this concept as effective coordination with the conflicting interest of the different people and the administrative cooperation to resolve amicably them any confrontation among the various groups working for the realization of their ends at any cost. Now this we know about that there are the different elements which is related to constitutional morality, like rule of law, individual liberty, freedom of choice, freedom of expression, social justice, procedure established by law, due process of law, right to equality, and preamble. Now the sources of the constitutional morality. The constitution itself is responsible for the origin of the concept and the events and requisites that unfolded during the constitutional history which at the time of the constitution was framed. And Dr. B.R. Ambedkar discussion, debates and views of modern day understanding in the Constituent Assembly are one of the important source of the constitutional morality. There are the two important concepts which are needed to uphold the constitutional morality, that is freedom and self-restraint, and the commitment to the ideals and aspiration of the constitution. Now, the drawbacks of the constitutional morality is the term constitutional morality has not been clearly defined and mentioned in the constitution, and the concept of constitutional morality introduced to create a problem amongst the power of the parliament and the three wings of the government, that is the judiciary, executive and legislature. And the separation of power has caused a lot of issues on constitutional morality against societal morality. I ended my part with this concept. Thank you everyone for listening me, and the next part will deliver by my co-author Najima Begum. Thank you.
Good afternoon, everyone. As my co-author Alka Patel have already discussed about the concept of constitutional morality, now I'm going to discuss the role of judiciary on constitutional morality. The judiciary has played a vital role in the development of this concept in various cases. In Naj Foundation versus government entity of Delhi. The Delhi High Court held that popular morality or public disapproval of certain act is not a valid justification for restriction of the fundamental right under Article 21. Popular morality, as distinct from constitutional morality, as morality derived from constitutional values, is based on shifting and subjecting motion of right and wrong of any type of morality can pass the test of compelling state interest. It must be constitutional morality. In landmark case Navteej Singh Johar versus Union of India, where the Supreme Court partially struck down the section 377 of the IPC and declared the provision as unconstitutional, is so far as it criminalized consensual sexual conduct between adults of same sex. The judgment of Navteej Singh Johar versus Union of India has given a new dimension to the concept of the constitutional morality. It has created a revolution, and it is hoped that in a future coming future as well, the Indian judiciary will incorporate the principle of constitutional morality in their judgments, so that the people can live happily and cooperatively in Indian society without violating each other's fundamental rights. Justice should prevail, and it must be main object of the state to maintain it. However, the concept has not been accepted vastly in the country. Various scholars have criticized this concept on various grounds, such as it lacks clarity, encourages judicial supremacy, having no explicit definition, etc. After the Sabrimala verdict, Mr. K.K. Venugopal addressed this this constitutional morality as a dangerous doctrine. Now, I'd like to conclude this discussion with a few words of Dr. B.R. Ambedkar. Constitution protects our rights all day and night. Thank you, everyone.
Thank you, Najima and Alka, for your presentation on constitutional morality, highlighting the revolutionizing judgments of the pronounced by the Indian judiciary in this regard, and the various connected theories and historical background. Thank you for the same. I now invite our next presenter, Anand Kumar, Assistant Professor, to be presenting on the topic Hate Crimes, a blot on the face of modern India.
Good afternoon, everybody. Am I audible and visible?
Yes.
Okay. My topic is hate crimes, a blot on the face of modern India. Basically, what we understand by hate crimes, they are different from general crimes or the regular crimes in the sense that in the hate crimes, the accused or the culprit, we can say, does not have any direct animosity, direct relationship with the accused. He commits this crime, the perpetrator commits the crime because he thinks that the victim belongs to a particular community, he has a membership to a particular membership or perceived membership to a particular racial group, caste, community, maybe religion, maybe language, or whatever may be the criteria. It may be sexual orientation, it may be disability, gender, whatever it may be. So these kinds of crimes generally send a message of hate against a particular community to which the victim belongs, and therefore they are also known as bias incidents or the biased crimes. In these crimes, basically there are two elements. One is that we can say that as base offense, which is the actual offense which is committed by the accused or the perpetrator, whatever be the nature of the crime that he has committed. And the second component of this hate crime is the specific thought process, or we can say the motive or the intention behind the commission of this crime, referred to as bias. So there are basically these two elements. The reasons of hate crimes, there cannot be a definite reason, there cannot be a specific reasons. There are a number of reasons varying from hatred, jealousy, peer approval. So they are not always motivated by single type of prejudice. In certain societies, when the society is structured in such a way that certain group of sections are given preference over the other, then we can find that in these societies, these kinds of crimes will be prevalent. Other reasons can be when the accused or the perpetrator thinks that he has emotional bearing against the particular victim who belongs to the target group which he doesn't like, or he doesn't belong to the group to which the perpetrator belongs. Or at an abstract level, we can say that the target may simply represent an idea that he is a different sexual orientation, he is a immigrant. So he doesn't like the idea of a person with a different sexual orientation. He doesn't like the person with a different culture, or maybe immigrant. So there may be a variety of reasons for the commission of these kinds of crimes. Coming to the effects of the hate crime, they have long-term effect on the society as well as the victim. It creates more of psychological distress on the victim other than the which we call as regular crimes, the normal crimes, because they are intended to intimidate the person in question, that we don't want you to belong to our religion, our country. We don't want you to remain here. So it makes an impression on the injured individual. They are not welcome, and therefore it has the effect of denying the victims right of full participation in the society, and therefore it can damage the fabric of the society and fragment the community as a whole. And therefore these hate crimes have been justifiably given in different jurisprudence. Increased punishment, increased sentences, increased penalties have been awarded for them. Coming to the constitutional provision, we see that every individual has a fundamental right to speech, religion, propagation of his ideas. But these rights, these fundamental rights, as we all know, they are not absolute. There are certain reasonable restrictions may be imposed, and as we see in the 19.2 and various constitutional provisions, there are a number of restrictions that can be imposed on these rights. Coming to the penal legislation, we can see that there is no specific legislation as of now in India dealing with the hate crime. So in general, we punish them under various provisions of the Indian Penal Code. As I have enumerated, you can see in the slide, there are different number of sections, 153A, 153B, 295, 295A. There are different number of sections dealing with the affecting the religious feelings and dealing with place of worship, trespassing burial grounds, different general kind of offenses which affect the religious sentiments of a particular group of community. But there is no specific legislation as such in India which deals with these hate crimes. So as far as judicial approach is concerned, there are a number of judgments. In 2014 also we saw a Pravasi case, 17, 18. But in the Tahsin Poonawalla case is the most important judgment, landmark judgment by the Supreme Court. In this case, Supreme Court laid down certain directives. In fact, Supreme Court recommended that the government should, the parliament should enact a specific legislation in dealing with mob lynching that time prevalent in this Tahsin Poonawalla case was also related to a place in Latehar in Jharkhand where 2 persons were killed, and consequently Poonawalla filed a case in Supreme Court, and Supreme Court laid down number of directives, and these directives can be laid down divided into 3 categories. The preventive measures, the Supreme Court said that every state government should appoint in each district a nodal officer not below the rank of superintendent of police to be held by deputy superintendent of office police to prevent the rising cases of mob lynching, honor killing, etc. Remedial measures, that immediately FIR should be filed, immediately charge should be filed within a specific period. Then punitive measures, that if the concerned officer does not take his duty seriously or fulfills his obligations, punitive measures should be imposed on him. So recently in April 2023, in a significant development, Supreme Court said that all states and union territories are now compulsory enjoined to take suo motu action and to file FIR against all those kinds of hate speeches which affect a particular community. Earlier in 2022, Supreme Court had passed an order to the Delhi, UP and Uttarakhand police only. But in 2023, Supreme Court extended this order to whole of India, and it has made it obligatory for all of states and union territory to take a suo motu action and to file FIR whenever there is such incident of hate speech in any part of the country. So in concluding part, I can only say that though our constitution guarantees number of rights to the individuals, we have freedom, fundamental right to speech, whatever we want, we can speak. We have right to religion, we can propagate our religion. But as the Hofield has said, the right is an interest that imposes a correlative duty. These rights are not absolute. And when we forget our duty, only emphasizing the right part, then the problem arises in the society, and then the state is forced to intervene. These kinds of hate crimes are great hindrance to achieving our constitutional goal of equality, justice, and fraternity. And therefore, as the Law Commission in its 267th report has recommended that there should be a specific legislation dealing with the hate crimes. So therefore, what we need right now is a comprehensive, specific, and a stringent legislation which punishes, which in fact gives severe punishment to these kinds of hate crime, whatever it may be form, its form may be mob lynching or whatever it may be. So today, as when we are going to moon, as 2-3 days back, we have seen the Chandrayaan 3. So when we are going to moon, this hatred of men towards men is completely acceptable, and what we need is to inculcate human values, moralities, and respect of human being. Only then, because we can make law, but as we have seen, there are a number of laws in the society, but unless and until we as an individual, we as the citizen does not respect the law, we are not going to, the society is not going to progress as a whole. With these words, I conclude my presentation. Thanks a lot.
Thank you, Mr. Anand Kumar, for your presentation. Indeed, in the light of the principles enshrined in the preamble and the Constitution of Equality, Justice, Fraternity, and in the light of the various hate crimes based on ethnicity, racial, race, or disability, or the sexual orientation, indeed, it is high time we really look into this matter with more focus. Thank you, sir, for your presentation. I would like to know if Mr. Sagar has joined the session for his presentation. I do not see Sagar present here. So if you have joined by any other name, please let us know. Mr. Sagar. Our next presenter, Kanhaiya Lal Rai. Are you present, sir? Kanhaiya Lal Rai. Our last presenter, Satavisa Bora Bashya. Satavisa Bora Bashya. Mr. Shivananda Sahu, I request you to please mute yourself. Mr. Shivananda Sahu. Yeah, thank you. So I'd like to confirm that Mr. Sagar, Mr. Kanhaiya Lal Rai, and Satavisa Bora Bashya are absent in this session. All right. So now we have ample time in our hands sufficiently to be able to accommodate detailed comment, feedback, or insights from our resource persons. We would like to start with Dr. Aprajita Borua, Head PG Department of Law. Ma'am, I invite you to kindly share your insights for the presenters. Thank you, ma'am.
Thank you, Priyanka. So indeed, actually, I was listening to all the presentations made by the learned presenters. And I think barring 4 presenters, all of them were there. And respected Mr. Atul Shahi, advocate of the Allahabad High Court, another resource person, and the learned presenters, and my esteemed colleague, Priyanka. So from the let us start from the first presenter onwards. Should I give comment from for all the one by one for all the presenters?
Yes, ma'am, you can.
Yes, ma'am.
So I believe that the first paper, which was presented by Shivani Datta on the aftermath of Ka, the part to statelessness. So invariably, yes, he has done all the nuances of the aftermath, the beginning of the Foreigners Act, and all the relevant dates also, and including the Assam Accord. But in her presentation, what I found that is missing is the solutions, how to give the solutions, because Foreigners Tribunal was created. Then they have declared many of these persons were there, no foreigners. So how to give the justice to that, to those people? So that is also missing in her paper. So so when we write the papers, actually, first of all, the data that we collect, the source, that has to be very clearly written. In some of the presentations, I have seen the references. Maybe due to non-presentation of these slides, that was missing in her paper. So is she there? She can highlight on that aspect as well, because solutions were not given. In which way the rights of these persons will be protected if they are declared as no, foreigners by the Foreigners Tribunal. Is she there, Shivani?
Yes, ma'am. Yes, ma'am.
Shivani, is she online? No.
Yes. Shivani, ma'am, can you hear us?
Okay.
Ma'am, we can come back to her towards the end of it.
So next one, Sangeeta Das and Umme Safia Begum. They have their slides are very beautifully placed. Then in their presentation also, the solutions part, in most of the papers I have seen that the suggestions, some of them they are giving, I have written down here that the slides are elaborate in nature, though even then the address regarding the exploring environmental climate justice, which refers to weaker sections of the society. So how did they identify the weaker sections? That is also not mentioned in their paper. So weaker sections in terms of what was the measuring the parameters, that was not mentioned in the paper. So when we write something, so we have to be very clear about it. That is also there. As the moderator has asked me to give critical comment on the papers, that's why I'm giving it to you, so that some modifications can be done. Then another this Raja Rajeswari in a student, the purpose which the climate justice serves. Now, the very title of the this particular virtual conference is Contemporary, this Contours of Law and Justice in the Contemporary Era. So emerging contours of law and justice in the contemporary era. So basically, so how to reconcile the law and the justice? Justice is for the person who has the grievances. So this is also in her area. I have found that altogether she has highlighted the problems. Then again, the solutions part and the maybe the workable solutions part, that is also to a great extent this is missing. Then she has highlighted on the awareness drive. So in which way that would be done, the modalities of the awareness drive, that is also not there in her, she has not mentioned about it. Then so far as the Dr. Upankar Chutia and Gyanasri Datta's paper, so they have undoubtedly they have highlighted the plights that some of the areas, some of the people that are facing in some of the areas of the entire state of Assam. They have highlighted about Dhemazi, then Dhubri, and many other parts of the state of Assam. But the data, how many districts were affected, maybe because of the climate, that the refugees, how many numbers are have been there in the refugee camps, and regarding the signing of the treaties and the conventions they have highlighted. But unless and until Government of India signs it and ratifies it, and then as in compliance with the Article 253 of the Constitution, if they do not make laws, they have highlighted on the incorporation or adoption of sui generis laws. But before that, the signing is required, ratification is required, then the national law is required. So everything is missing in this regard. So it is very difficult to have a proper legal framework. So how to advocate, how to have a clear law in this regard, that is also not there in their work. Okay. Then,
thank you, ma'am, for your review, ma'am. Thank you, ma'am. We'll truly incorporate those things.
So
thank you, ma'am.
Data, yes, data.
Thank you,
how
madam.
many
Thank you,
districts?
madam.
Means
Correct.
figure we should include
Correct,
from the source from where we have got the data.
Correct.
So that it becomes more authentic, and we should not attract any provisions of the plagiarism.
Thank you, madam.
Then Mujismita Barua's paper as well, also highlighting on this aspect, role of international human rights in combating adverse effects of climate change. So different conventions he has highlighted, no doubt, but the conference of parties at different point of time, it has highlighted on the issues of climate change, and right from the Brundtland Commission or the UNFCCC, so 1992 onwards. However, the problem that the people still are facing. So the stringent laws have to be made by the government, and the stakeholders should be united, so that climate change can be, to a great extent, can be eradicated or maybe stopped. Then in Medha Tiwari's presentation, social media intermediaries and democratic culture, a legal reflection. It is a very good paper. I have seen it, and lastly, she has mentioned 6 suggestions. So in one of these suggestions, she has stated that ethical content moderation. So if she's there, can she highlight on that aspect? Ethical content moderation. So in which way we will, I just want to know about it, actually.
Hello, ma'am, I'm here.
Please highlight on the Medha Tiwari, is because you have, your presentation was very, very thought-provoking and well narrated. And you talked about the internet freedom also. And suggestions, 6 suggestions. I guess you provided 6 suggestions in one of your slides, right?
Right.
In one of your slides. Am I audible to you?
Yes, ma'am, you're audible.
So in one of your slides, you have mentioned about 6 suggestions. One of the suggestions was ethical content moderation. Would you like to highlight before the house?
Sure, ma'am. When I talked about ethical content moderation, all I was talking it with the issue of constitutional morality. That is, the content moderation must be keeping in line the public policy that is at place as of now, and the high ground that is taken in society. That was all I was trying to put up with the help of this.
Okay, thank you.
Thank you so much, ma'am, for the feedback.
Thank you. The next one, Biswadeep Datta. So it was a very narrative one. So again, regarding Bandita, Dr. Bandita Sengupta's presentation also, I have seen that education and the tribal people in India. So the scattering or the localities or the pockets or the universe of these tribal people where they are located. That is not initially mentioned in our paper. Then what are those rights which are available as per the legislations that are there in the extant legislations that are there in India? So you have to highlight on these aspects clearly. Then suggestions regarding the upliftment of these sets of people, regarding the how to secure their rights more effectively. It's true that different provisions are there in the constitution, also separate laws are there, but still they are regarded as downtrodden or the underprivileged. So how to bring to them to the mainstream to a great extent, that is also required. Then in Chanpreet Kaur's paper, so basically the right to bodily integrity and reproductive rights of women. So far as these things are concerned, no doubt you have highlighted on these aspects. How to secure these rights? How to secure these rights? That is actually, you talked about the surrogacy also, to have children also, the reproductive rights on all these things. How to secure these rights without certain concept, like some legal as well as non-legal issues. One is the poverty, another is the education. The linkages between the protection, the right to bodily integrity, as well as poverty, as well as education. These things were not highlighted in your paper. I think that can be another insight. You can ponder over it.
Okay, ma'am. Thank you so much.
Yes, because bodily integrity, unless and until we know about it, education, then poverty, that I think these are some of the important areas which were highlighted in the CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women. So these things can be highlighted. Otherwise, it's a very unique paper, and it also manifests the interface between law and justice. Then we have the paper from our student Nazima and Alka. It was a very thought-provoking. Within very short span of time, you have highlighted, it's a very big area, though constitutional morality and democratic ethos, emerging area, and you have highlighted the case laws also, and the development that has taken place. One thing that can be done, when you presented the different aspects of the constitutional morality, you have not directly mentioned the cases where it has come up. Got it? So that can be done. So when we talk about the different areas, different concepts which has maybe by way of pronouncement of judgments, when it has come to the fore, so immediately we should know the concept side by side, the relevant judgment that is required. Okay. Then lastly, I think it is Anand Kumar. So it was also very informative, all the slides and the case laws also. Congratulations to all the presenters. And within such a short span of time, you have, all of you have tried to present before the resource person your topics of choice. And I must say that the arrangement by the organizers, it is really commendable. Thank you all.
Thank you so much, ma'am, for always extending your help and cooperation in the organizing committee whenever we required. And thank you for taking out your time to share your insights for the presenters. We now move on to Atul Shahi, sir. Sir, I would also like to bring to your and ma'am's attention that one of the presenters who was not there, Satavisa Bora, has joined now. So would you like to share your thoughts on the presentations now, or should we? Would you like to share it at the end of our presentation?
At the end would be better, I think.
All right, sir. Satyavisa, can you hear us? Satyavisa,
yes, ma'am. Yes, ma'am. Yes, ma'am. I can hear you. I have some network issues. That's why I cannot join on time. Sorry for that.
Are you ready to present your paper?
Yes, ma'am. Yes, ma'am. I'm ready to present my paper.
All right. So I invite Satyavisa Bora Vaishya, academician, to present her paper on role of forensic science in the criminal justice system.
Okay, thank you so much, ma'am. So may I proceed with the paper?
Yes, please. You have 5 minutes time.
Okay. So my paper is role of forensic science in criminal justice system. And as we know, justice do not come with a single click or a blink to anybody. It takes incredible several moves to the development of time. There has been considerable development in the process of judicial system. There has been remarkable penetrations of technology and techniques in the process of solving the crime. In this, forensic science proves to be the helping hand in this regard. The word forensic means about the law. So logically, forensic science involves the application of scientific principles to legal investigations. Now, the word forensic is rooted in the Latin word forensis, the dictionary meaning of the word foreign to the courts or law or relating to the court of law. But in legal terminology, it may mean the science which deals with the principles and practice of different branches of science, which elucidates doubtful questions in the court of law. Now, there are certain objectives in case of forensic science. The first objective is to ascertain the importance of forensic science in the field of law, to ascertain the issues and concerns of admissibility of various kinds of forensic evidence in the legal regime, provides necessary service to concerned agencies by analyzing and testing the physical evidence pertaining to the investigation and justice administration. It also helps tribunals to find facts by giving scientific opinion and appearance in law court as an expert witness. Now, my research methodology is this paper shall follow a theoretical research methodology. The scope of this paper shall be limited to the value of forensic science, generally and not specifically to one of its field. Now, my next is forensic science in criminal investigation. Forensic science is an important feature of the criminal justice system. Essentially, it deals with exploring the scientific and physical clues collected from crime scene. Forensic science describes the subject distinctive nature with crime. The evidence clearly points out the essence of the crime that was committed. The circumstantial evidence even refers to the time of the occurrence of the crime. The forensic evidence indicates where is the crime or where the crime is located. The forensic investigation even follows the offender's process. Now, investigating a criminal act, the large area of forensic science and forensic resources are involved. During the entire criminal investigation, the evidence is collected from the crime scene, which is further analyzed in a forensic lab, and thus the findings are reported to the judge. Now, the forensic science and its legal provisions in India. Section 45 and 46 of Indian Evidence Act offers a quick summary of the admissibility of forensic evidence in the courtrooms. The following may be found in 45 and 46. When required, the court will depend on the experienced experts with technical and field knowledge of the facts described in the case. The court will depend on the report presented by the official or expert who arrived at his conclusion in good faith, utilizing a range of techniques. Any evidence that appears irrelevant to the court, but it is important in the expert opinion, will be given relevance as a result of the expert opinion. Section 73 of the Indian Evidence Act directs a person can be asked to give a fingerprint or DNA examination, even if they are the accused. Now, the Criminal Procedure Code has several provisions and
Satyavisa ma'am, you have noted.
53(1) of CRP states that an accused may be investigated by a medical practitioner at the request of a police officer who is using reasonable force. Under Section 54 of CRPC, a medical practitioner may examine an arrested person at his request in an attempt to identify the evidence in his favor. Now, there are many principles of forensic science. They are Locard's principle, law of individuality, law of exchange, law of progressive change, law of comparison, law of analysis, law of probability, and law of circumstantial facts. Now, there are though forensic science has played a pivotal role in our society, but there are also some drawbacks. Forensic science. They are DNA analysis of a person is believed to be against human ethics as it reveals private information about an individual. Equipments used in forensic is of great expensive. It's very expensive. That is why it's one of the drawbacks in forensic science. Scientific analysis consumes a lot of time, because of which the verdict is delayed. The evidence cannot be accessible at all the times. Now, the findings and conclusion from this paper is that forensic science and law is closely related. They are like the two sides of the same coin. The forensic science refers to the application of scientific methods, procedures, techniques directed to the recognition, identification, individualization, and evaluation of physical evidence by the application of the natural sciences to the law sciences matters. Regardless of the area of subspecialization, forensic science involves the application of scientific principles and methods to evaluation of evidence. The law recognizes the importance of forensic evidence in prosecuting criminal cases. When scientific methods are rigorously used with prejudice, they can provide cognate evidence in uncovering and providing crime. It provides crime beyond reasonable doubt.
Ms. Sattavisa, if
Yes,
5 minutes are up, we request you to kindly conclude as soon as at the earliest.
Okay. Okay. Now for the suggestions, I want to say that forensic science has grown in its complexity and the importance over the past several decades. This has led to a greater demand being placed on law enforcement. In several cases, law enforcement has been questioned and criticized in identifying, securing, and handling of critical forensic evidence. There is a clear need for law enforcement personnel to be more knowledgeable about forensic science as well as of the criminal investigation procedure. Thank you.
Thank you very much. I'd like to call upon once again Sagar and Kanhayalal Rai. Are you there in the session? Mr. Sagar and Mr. Kanhayalal Rai. Okay. So, Sattavisa ma'am, you can mute yourself again. Ma'am, would you like to give your comments on her presentation and then we'll move?
It was fully informative, and plus she most probably what I was pointing out a few moments back, everything she has highlighted, when that means the methodology she has incorporated in her paper, then it was a very thoughtful presentation. I should not say anything. Yeah, thank you.
Thank you,
nice
ma'am.
presentation. Yeah.
You had a question earlier for Shivani Datta, ma'am. I think she has joined. She is there now. Is it audible?
Shivani Datta.
Shivani Datta.
Regarding the suggestions part.
Yes, ma'am. Sorry, I was like, I was not on time. Sorry, I'm here.
So highlighted the issues, but the suggestions in which way that will be, addressed.
Yeah, sure. I will put it in the paper. Like I will definitely.
So that it will be more, more feasible and it can be assessed in a better way.
Yeah, sure, ma'am. Thank you for your feedback.
Thank you, ma'am, once again. And I would like to call upon our second resource person on this technical session, Atul Shahi sir, who is an advocate of the Allahabad High Court, to kindly share his thoughts and insights for the presenters.
First of all, I thank you to Gulati Law Chambers and Ms. Priyanka Majdar for giving me as a resource person for this session. And I warmly welcomes to all the participants who have beautifully presented their papers. I'll not go one by one, but yes, for Shivani Datta, I have some question if you're online. Are you there?
Yes, I am.
Okay, I was going through your papers and your presentation. You have not mentioned anywhere whether similar law is there in other countries or nation. I mean, there's no comparative studies in your paper.
It's not a comparative study.
Yeah, that's all. That is all, what I'm saying. That is not a comparative study. You have focused on CAA, and you have mentioned some act of National Registration Act in Assam, right?
Yes.
How does it similar to CEA, or how does it differ to CEA?
How is it different to
CEA?
Yeah. And how is it different from like which law you are talking about?
Amendment Act, CAA.
Yeah. So
And how is it?
I'll just brief you how it is, like, more implied to the state of Assam, because out of when we had the NRC process in Assam, there was a thing that those who are not in the NRC will be considered as illegal migrant. However, after the CA was brought into the picture, from that category, only the ones who are minority from those particular states can apply for citizenship. So that is how it is more when it comes to the state of Assam, it has a different impact compared to the other states of India.
Okay, and you have mentioned that it is a volatility of Article 15.
Yes.
Does CA Act has mentioned anywhere that it is a communal based?
No, it has not mentioned, but it has definitely mentioned. I have never used the term communal, but I have given Article 15 for the reason that we cannot make a law only on the basis of religion. And definitely it is a religion, how it has been brought into while determining the minorities or the majorities from the particular countries.
But CAA is not meant for distinction between minorities and majorities, right? It is a citizenship amendment bill that who are illegal migrant has to go out. It is something like that.
I would just like to highlight that it does not say so. They have not used the term illegal migrant in CAA.
Okay. Okay, and I'm moving next to Ms. Sangeeta Das and Ume Safia Begum, along with Bhargav Manyav and Gopika S. Nair, together with Dr. Upankar and Gyanashri Datta. You have focused mainly on Assam states regarding climate changes. You have not focused any other states. There's no comparative studies in your research paper. Like flood problem is always there in MP and Uttarakhand. Are you there? Someone's there from these men? Dr. Upankar is there? I think he's not.
Yes, sir, he's there. He's muted. Dr. Upankar.
We are there, sir. We are there. Yeah.
Okay, I was asking that you have focused only on Assam state, that flood problem is there, climatic change is there, but there's a lot of climate change problem in Uttarakhand also, in Himachal Pradesh also.
Definitely, sir. Actually, what we tried to do was we tried to narrow down a topic. No doubt, if we do a comparative study, it becomes much more wider in scope. So, of course, being from Assam, I am basically from Digboi, right? So, basically stating on that, seeing the problem and Assam being a vulnerable state now to such problems, being, a victim of flood, victim of so many other things due to climate change. That's the reason we try to narrow down the scope and we try to focus only the place of Assam. And why our law is still not there today, which is actually, focusing on this issue, climate migrants of. That's the thing. Because if we would have done a comparative study, but that would have been much. Since we thought this is a research paper, we thought we will just narrow down the scope so that it becomes much more visible to them.
Because you have mentioned law sui generis, therefore I was asking this. And the question is, when NGT is there in Delhi, have we heard about the NGT? It deals with these type of problems.
Yes, sir.
Yes, sir.
Yes, sir.
It is for these type of problem which coming towards the hilly station, especially the states under river surrounded area or mountain area. The NGT problem is there, which they are dealing with the matters. And the only concern I was that there's problem of climate change in other states also, like Uttarakhand and Himachal Pradesh. So, and no suggestions have been made, as mentioned by our first spokesperson, that there's no suggestion from your side that what has to be done to deal with these type of problem.
So this you was speaking, like saying in the context of our paper or the previous presenter, right?
In almost all 2-3 papers. Okay. Yeah. And about Medha Tiwari, I was highly impressed, very beautiful presented, and no doubt this is a very good topic to be discussed about regarding internet freedom, because this is a prevailing topic which is going on almost in every state. Is Mr. Datta is here? I think he's left.
Mr. Biswadeep Datta, are you there in the session? Yes, sir. I think he's not there in the session.
Dr. Vandita Sengupta, are you there? In her research paper, she has not mentioned that National Education Policy of 2020, which is not only caste-based, rather tribunal based also. The central government has issued various guidelines in their NEP 2020 and recent studies of 2023. So these things are missing. And again, as said by the ma'am, suggestions are missing. And is Ms. Chandpreet Kaur is there?
Yes, sir.
Yes, sir, I'm here, sir.
Yeah, your paper was beautifully presented. I must appreciate. But you were talking about the right. So
Yes,
you have not made any suggestion how this right can be enforced. Once regarding abortion, I think PCP and DT Act is there. It's bar abortion, about sex attention test also.
Yes.
At what stage the abortion is permissible, everything is written that is but how the right is affected and how the right can be enforced, these two suggestions are missing in your paperwork.
Yes. Okay. I'll
Regarding
definitely.
adoption, there's also an act, Adoption Maintenance Act, you might be heard about.
Yes, sir.
1956. So
Yes.
is there any new thing to be added? These
Yes, sir.
suggestions are missing. Otherwise, your paper is beautifully presented.
Thank you so much, sir. Thank you, sir.
Okay.
I will add on to these things. I'm in the process of developing it further. Thank you, sir.
Thank you. Thank you. And about Anand Kumar, hate crimes, I appreciate
sir.
that he has tried to focus on every topic. Targeted crimes also, criminal crimes also, and no doubt, mob lynching is being a debatable topic since a long. The first incident was 1784, I think, Gujarat riots case. After that, several incidents has been taken in Jharkhand, the Maharashtra. No doubt, it is a very good topic to be covered by you. I appreciate and I congratulate to you.
Thank you.
Lastly, Ms. Satyajit Bora, regarding forensic science, are you there? Satyajit Bora?
Yes, sir. Yes, sir, I'm there.
Okay.
Yes,
You
sir, I'm
have
there.
actually, quoted your relevant provision of Indian Evidence Act, how these provisions are relevant in Indian judiciary. But once again, the suggestion is missing that how the forensic side can more be reliable in Indian judiciary and during the trial. This thing has to be implemented, that forensic science has to be used during investigation, and what is the evidentiary value of collecting forensic evidence in the trial, because when it comes to a trial, then evidence act is started. Evidence act doesn't apply during investigation, so these suggestion has to be implemented. Otherwise, your forensic science
Okay,
topic is
sir.
very
Okay, sir, I'll keep.
very well presented by you. Thank you.
Thank you, sir.
And Ms. Majumdar, I'm
Thank you, sir.
done with it.
Thank you very much, sir. I'm sure the suggestions given by our resource persons will go a long way in helping the participants further, develop their paper and make sure that it is really comprehensive in all aspects. Thank you, Dr. Prajita Barua ma'am and Atul Shahi sir, for taking out your time and giving a detailed suggestions for every presenter. Thank you so much. At the end, last but not the least, I thank all the participants for joining this session. I'd like to inform that our next parallel sessions, technical sessions 3 and 4 will be starting at 3 p.m. The links are available and have been shared with you in the group, so kindly join accordingly. Thank you.
Thank you.
The participants are free to leave the session.
नहीं, कारीगर है।
If you guys laugh
Sir, am I audible?
Yes, you're audible. Has both the resource persons joined for the session?
Just 1 minute.
Shivangi, has both the resource persons joined? I can see Aman sir has joined the session.
Yes, sir. Aman sir has joined.
And Stuti?
I'm just waiting. I'm just waiting for Stuti, madam.
Okay. Just write a message in the group so that Karavi madam can just contact the resource person.
Yes, sir. Sir, both the resource persons have joined. Shall we start?
Yes, Shivangi, can we just begin with the session?
Yes, sir. Thank you, sir. It's a pleasure having everyone here this afternoon. I, Shivangi Goyal, Advocate Guwahati High Court and the moderator for today's technical session 4. I welcome each and every one of you for today's virtual national conference on emerging concourse of law and justice in the contemporary era, issues and challenges. Organized by Postgraduate Department of Law, Guwahati University, Assam, and Direct Panel Group, a unit of Arjun Das Gulati Memorial Society, Prayagraj, in collaboration with Guru Angad Dev Teaching Learning Center, Pandit Madan Mohan, Malviya National Mission on Teachers and Teaching, Ministry of Education, Government of India. I would like to welcome our resource person for today's session, Professor Stuti Dekar, former Head and Dean, Faculty of Law, Guwahati University, and Mr. Aman Singhania, Advocate, Supreme Court of India. Before starting with the session, I would like to inform all the participants with the rules of the session, that is, you will be given 5 minutes for your presentation. After 3 minutes, you will get an alert. Ma'am and sir, your kind concern, with your kind consent, shall we start with the session?
Yes, we can start.
Thank you, ma'am. Now, I would like to invite our first presenter, Pooja Bigargi. She is an academician, and her title and her paper is Law Relating to Abuse of Senior Citizens in India.
Good afternoon, one and all. I hope I am audible.
Yes, you are.
Ma'am, with your permission, can I share the slide?
Yes, you can.
Yeah, thank you so much, ma'am. So my topic for today is laws relating to abuse of senior citizens in India. Now, speaking about the human rights which is available to each and every person, irrespective of the age, sex, caste of a person. Aging is something which happens on a natural process. It's a human life, and we have also seen that during the process of aging, the older generation, that is particularly the senior citizens, are left with no care, no one to look after them. We see that they are being victimized, they are being neglected, not only by their family members, but also by the people who are surrounded by them. So we say that there is something called as abuse which is happening to these people. Abuse could be in the form of injury, which is happening not only physically, psychologically, emotionally, which is degrading or it is depressing for these particular people. Physical abuse might be in the cases of injury, some cases of physical force which is inflicted on them. Emotional abuse could be because of the insults or degrading their status into the family. There are numerous cases where we see financial exploitation which is happening to these people, where they are being forced to work even after the retirement age, or they are being forced that they should support financially to the family. It has also been seen that senior citizens are forced by their own family members to be within the house and take care of the household chores. There are cases of misbehavior, mistreatment which is happening to them. The intention of doing this research is that this misbehavior, neglecting or attitude of the younger generation, or we can also say the victimization which is happening of the older section, the senior citizens, should be stopped, and it should also be punishable. Now, speaking about the laws which are being enacted to ensure that there is no abuse or the senior citizens are being protected. So we see that as per the Constitution of India, everyone has a right to life with dignity. Therefore, we see under Article 41, 46 that basic rights should be provided to the senior citizens. Moving towards the personal laws, we have seen that Hindu law, that is Hindu Adoption and Maintenance Act, says that a child, a son or a daughter, is having a legal obligation to take care of their senior parents. As per the CRPC laws, Code of Criminal Procedure, we again see that maintenance is to be provided to the parents who are not able to take care of themselves. There are numerous schemes, policies which have been enacted by the government. There are numerous NGOs, just to name a few, the HelpAge India or Age Well Foundation, which is not only supporting them, that is to the senior citizens financially, but they are also providing emotional support in the cases of counseling. Moving towards the judicial actions.
And your 3 minutes are over.
Yes, ma'am. Thank you. Moving towards the judicial actions, we have seen a trend in the Supreme Court, in the lower courts, in the high courts, that they have been numerously trying to make sure that the rights of these senior citizens are being protected. Just to go across these case laws, in one of the case laws, Sunny Paul and another versus State of NCT of Delhi and others, it has been stated by the Delhi High Court that as long as the parents are having legal possession of their property, they can remove their abusive children if there is such a case. Also, this particular case law is not only limited to the children, but it will also be extended in the cases of married couples to the in-laws, that is daughter-in-law or son-in-law. Another case law to be pointed out is the Supreme Court in this case stated that irrespective of the case, whether the daughter is married or she is unmarried, she is having an obligation to take care of their parents, subject to the condition that there is no one else to take care of the senior citizen, that is their parent, as well as in circumstances where she is married. In another case law, we again see the cases of eviction, which is possible, where we see abuse is being done on to the senior citizens. So my conclusion and suggestion for this topic is Definitely there are policies, there are schemes, and there are laws, but yet we need to amend these legislations, we need to amend these schemes and policies. We need to come up with sensitization of this particular topic so that there could be counseling sessions provided to these older generation people, and there should also be a provision. Thank you, ma'am. We should come up with a punishment scheme. Thank you so much, ma'am.
Is there any question? I'll go with the presenter. Our next presenter is Kosti Vaishali Ramcharan and Dr. Chetna Bujat. They are the research scholar and their topic is Expanding Horizons Consumer Right under Consumer Protection Act 2009. Kosti Vaishali Ramcharan and Dr. Chetna Bujat.
Am I audible, ma'am?
Yes, you are audible. You have 5 minutes.
My topic is expanding horizon consumer right under the Consumer Protection Act. As we know that we all are consumer in one form or another, but in the present scenario, we find that consumer is a victim of the many unfair and unethical tactics adopted in the marketplace. The untrained consumer is no match for the businessmen marketing goods, services on the organized basis and by the trained professional. He is very often cheated in the quality, quantity, price of goods or services.
I just want to intervene. Hello,
Yes,
first you just open your video. I just want to see you.
मैं मारा वीडियो नहीं देखा तो आवा मैम एक 1 second ना अरे
You just on the video and continue.
आपको ओपन किया ना
If there is problem, then it is okay.
Yes, ma'am. There is technical. There is a technical
Okay,
issue, ma'am.
no problem. Continue.
Thank you, ma'am. For the consumer, he is not supply adequate information as the characters or of many consumer goods suffer due to unfair trade practice and any kind of standard form of contract. In the modern economic and industrial development of freedom of contract, largely matter of fixation of many consumer are concerned. The consumer are need to provide protections under the any law. So basically, I would like to highlight in this paper some key features of the Consumer Protection Act. And by analysis, new concept introducing like as a CCPA, change in a pecuniary jurisdiction, mediation, public product liability, and so on. National Consumer Day is observed on 24th December in every year. This is highlighted that importance of consumer movement and need to make consumer more aware of their rights and responsibility. With globalization and development in international trade and commerce, there has been substantial increase of business and trade, which resulted in variety of consumer goods, services to cater to the needs of the consumer and particularly consumer rights. In the present year, there has been a greater public concern over the consumer protection issues all over the world. Taking into the account the interest and need of the consumer in all countries, particularly in those developing countries, consumer protection measures should be essentially be concerned with the protection from the hazard to the health and safety, to promotion and protection of economic interest, access to adequate information, control on misleading advertisement and deceptive representation, consumer education, and effective redressal. The consumer deserves to get what he pay for in real quantity and true real quality. In every society, consumer remain the central gravity of all business and industrial activities. He needs protection from the manufacturer, from the producer, supplier, wholesaler, and retailer. Consumer Protection Act 1986 was enacted to provide for better protection in the interest of the consumer and for the purpose of making provision for establish of Consumer Protection Council and other authority for the settlement of the consumer dispute. Although the working of Consumer Dispute Redressal Agency has served the purpose to considerable extent under the said act, the disposal of cases has not been fast due to the various constraints. The consumer market for goods and services have undergone drastic transformation since the enactment of the Consumer Protection Act 1986. The modern marketplace contains a plethora of products and services. The emergence global supply chain, rise in international trade, and rapid development of e-commerce have led to new delivery system for the goods and services and have provided new options and opportunity for the consumer. Equally, this has rendered the consumer vulnerable to the new form of unfair and unethical business practices, misleading advertisement, telemarketing, multi-level marketing, direct selling, and e-commerce pose new challenges to the consumer protection.
Ma'am, your 5 minutes are over.
Ma'am, lastly, I conclude my research paper that we can say like that under the Consumer Protection Act, the process of drafting which started in 2010, one of the sincere steps taken by the central government for enhancing consumer rights and speedy delivery of justice. The act touch on many aspects, mediation, e-commerce, that is the need of the new era. And so it was important to amendment the act, and digitalization has changed by the way of consumer conduct online transaction, e-mode payment, offline, online shopping. Certainly, this act is the positive step toward the reformation, development, and enhanced consumer rights. But economic and socially development taking place every year, and we can expect a new amendment to the enact this act. And but the real implement of 2019 act will be coming time and analyze how much relief is offered to the consumer. Thank you, ma'am.
Ma'am, any question?
So regarding this paper, you have discussed everything, but regarding that case law, you have not a single case law you have discussed here in this paper. What is the reason? Vaisali, Kosti Vaisali?
Nothing, ma'am.
Generally, in legal paper, the case laws has to be discussed, but you are not discussing, is not it? So what is the original act, Consumer Protection Act? Original act was, in which year it was enacted?
1986, ma'am.
1986. Why it was amended? Yes. Why it was amended in 2019?
There is a change in a consumer and expand the consumer rights and online shopping, transformations, and not speedy justice in the previous act, and many aspects are not covered under the old Consumer Protection Act 1986, like e-commerce related mediations, and there is no central authority to
Yes, yes. So you have done a very good work, but there must be some case laws. Anyway, so next.
Sorry, ma'am. Yes, yes.
Our next presenter is Ruchira Chaturvedi, research scholar. Her topic is Fiscal Federalism through Cooperative Federalism, Balancing Centralization and Decentralization in India's Globally Integrated Economy.
Am I visible and audible?
Yes, ma'am, you are.
A warm greeting to the resource person, Professor Stuti Rekha and Mr. Sharma. My topic is fiscal federalism through cooperative federalism, which aims at understanding cooperative federalism whether it can balance the centralization and decentralization in India's globally integrated economy. In trying to ascertain this, the entire research work is based upon the research question that for a globally integrated economy, is cooperative federalism the instrument to balance decentralization with centralization in the fiscal federal system? So in doing so, the research work is a doctrinal study and it is divided into three major parts. The first part is dedicated to the understanding of the concept of fiscal federalism and the essence of subnational government's autonomy in a decentralized system. The second part explores the nature of centralization that is introduced by 101st Constitutional Amendment that was introduced in 2016 and tries to ascertain its impact on the fabric of fiscal federalism in India. It further goes on to analyze whether decentralization is one of the key elements of the federal system or not. And it argues that centralization may not always be against the scheme of federalism. The third part discusses cooperative federalism as an instrument to balance without changing the fabric of or the scheme adopted for fiscal federalism. Cooperative federalism as an instrument to balance decentralization, which is considered to be an element of federalism, and centralization, which is considered to be a necessity for a globally integrated economy. So beginning with the first part, fiscal federalism is the economic counterpart of political federalism. Therefore, to fully comprehend the underpinnings of fiscal federalism, it is essential to understand the political federalism, which is crucial in analyzing what fiscal federalism would finally entail. So the basic concepts of federalism include the understanding of federal political system and the idea of autonomy of the federating units. The term federalism is derived from the Latin term fidus, which means treaty or pact. So it refers to constitutionally allocated distribution of powers between two or more levels of government in the modern nation-state system. So federalism is a constitutional mechanism for dividing powers between different levels of government in a manner that the federated units enjoy substantial constitutionally guaranteed autonomy over certain policy areas while sharing power in accordance with agreed rules over other areas. So on the basis of this analysis, I have gone through certain definitions of federalism. Like one of the definition given by International Institution of Democracy and Electoral Assistance, they have given the definition of federalism as with four major constituent elements. The first is it is a constitutional mechanism for identifying more than one unit, or we can say more than one level of governance. Second is it is a mechanism that formally divides power of governance between the identified units. Third is that the federated units share power in the common area in accordance with agreed rules. This reflects the idea of decentralization. And fourth is that federated units have substantial autonomy guaranteed by the Constitution over defined distinct policy area. This reflects the idea of autonomy. Now,
hi, Ruchira. Sorry. If I can just ask a question over here. When you talk about federalism, is the concept static in a sense that that federalism can be called federalism only if it falls within a particular structure? Or can federalism have different facets in the sense that different countries can adopt different methods of federalism? For example, let's say Indian federalism is probably very different from American federalism. The division of powers between state and center can be different, 60-40, 70-30, 90-10. Or does it have to be 50-50?
No, actually, the point that you have made is fair and is right, that there cannot be any ideal system of federalism. When we begin with the study of federalism, we start with the idea that American federalism is the ideal federalism. But now that we have gone through, we have immense literature, we have immense knowledge pool here on federalism, we cannot say that American federalism is the ideal federalism. Federalism is simply a notion, and it has certain key elements. So whichever legal system has those key elements adopted in whichever degree, just adoption of those key elements would suffice to call that system a federal system. That is why Indian system is equally a federal system as that of the American system. And this has been clarified by H.M. Seervai in his book as well, wherein he has disagreed with the idea of K.C. Ware calling Indian federalism as quasi-federal, and he has given his arguments on each and his counter arguments actually on each and every argument that is given by K.C. Ware. So on this basis, actually, I have also jotted down some of the key elements of federal system, which may be present in the legal system in varying degree, but their mere presence would be enough to call the system a federal system. Like first key element is there are 2 or more orders of the government, each with ruling power directly upon the citizen. The ruling units are independent in their respective areas of competence.
Ma'am, you need to stop. Your 5 minutes are over.
But I have a long list of arguments to present here.
Your 5 minutes and plus your 30-second grace is over.
Okay. So if any other questions or suggestions are there from the resource persons so that I can improve my work.
But it is impossible to give any suggestion because we cannot hear the whole paper as a whole. Anyway, it is a very good paper, and you have discussed on a financial aspect regarding cooperative federalism. So how it is centralized, that is the balancing centralization and decentralization regarding federalism aspect particularly in India. How you will define it?
Ma'am, I have tried to understand cooperative federalism. I have tried to analyze what that term cooperative federalism exactly means, because when the moment we use cooperative federalism, it signifies that it is an abstract idea. And being so, it is very hard to put that abstract idea in a straitjacket formula. So what we have deciphered by studying the idea of cooperative federalism is basically the idea of coordination, which is very much subjective to specific interaction and the terms of relationship between the center and the state. Going by that idea, in this research analysis, the study is limited to understanding whether cooperative federalism can be a solution to balance out centralization and decentralization, to which the answer is yes. Cooperative federalism can be a solution. But in order to actually effectively implement that solution, it would be necessary to understand and to standardize the concept of cooperative federalism so that it can actually be implemented effectively.
In India?
Yes, ma'am, in India.
Yes.
Thank you. We'll go ahead with the next presenter, Gayatri MR, PG student, Constitutional Right and Same-Sex Marriage.
Ma'am, am I audible?
Yes, you're audible.
So, good afternoon, everybody. Myself, Gayatri Amma, student of School of Legal Studies, CUSAT. So, first of all, I would convey my thanks to the postgraduate law department, Guwahati University, to conducting the national conference on this topic. So moving on to my topic, constitutional right and same-sex marriage. We all know that our Indian constitution provides some kind of rights, fundamental rights and fundamental duty to our Indian citizens. So does this right is applicable to the same-sex couples is one of the question, and debatable one also. So the convention and Article 14 and 15, 21 of the Constitution is always protecting the every people of India, such as while noting that the same-sex couples also should be protected from under this article. But there are some situations they are not protected under this articles also. And also moving on to the section 377 of unnatural weapons mentioned under the Indian Penal Code 8060 is also a kind of a violative principle, a violative provision for the same-sex couple. And moving into the one of the landmark case laws, Navatej Singh Johar versus Union of India, were discussing about the same-sex couples or same-sex people's rights are violated under the Article 14 and 15 and 21 also mentioned the provisions of 377 of IPC. And moving on to there are so many provisions, there are so many cases such as NAS Foundation and also NELSA versus Union of India were recognizing the transgender community. And we also know that there are the personal laws in India, such as a Hindu marriage as Christian and Muslim law doesn't recognize any kind of same-sex marriage, and we doesn't have any kind of proper definition under this any personal law about what does mean by the marriage, but it can consider that marriage is between the practices of men and women. So concluding that marriage is something which is meant to be procreation of a child. So when this same-sex couples are getting married and they can even procreate the child, and also the adoption is also maybe make some impossible for them. This is one of the disadvantage that they having when they get married. So same-sex marriage is something when man and man or woman and woman getting married. So concluding my argument on this issue or constitutional right, even though the constitution providing the Article 14 and 15 and 21 to these people, but it's still violating some way. Where there doesn't give an equality before law and equal protection of laws as such same to other person, and they are discriminating on the basis of their sex and gender, race every time when in the India. And about the right to life and dignity is not available to them, even though every person, even they are being an LGBT community, doesn't mean they have to discriminate on this basis. And also they have the at least they have the human rights under the UDHR and ICCPR. They guarantee that every human being, when they're born, they have the equal rights and dignity. And to concluding my opinion, India is a developing country as such as they are not developing in certain cases where they're still standing on some historical way. And also I concluding with a suggestion that we have to uplift these people, and we have to make some legislative framework for them to protecting these people's right, and should make that if a person has any attraction to their same sex, should be legalizing their marriage. It doesn't mean that we have to marry the opposite sex only. So this is all about my opinion on this topic. Thank you.
Thank you, Gayatri. You have done a very good work, but the government of India has not legalized same-sex marriage till date, isn't it? And it is the case law regarding same-sex marriage is reserved. The Supreme Court has not decided till date, but according to you, it should be legalized, isn't it? So you have discussed NAS Foundation case, etc. Very good. And you have done well. You are from Law Department, Guwahati University. Is it?
I'm from the CUSAT, Cochin University, Kochi.
Cochin. Oh, you are from Cochin. Kerala.
Yes. Kerala.
Okay, okay. So I have no questions regarding this thing. So Supreme Court has already ruled in favor of LGBT. So in which case? And in which year? That is the first and last question from my side.
Sorry, ma'am, I'm not.
You have discussed it.
Yes, ma'am, it's Navatej Singh Johar case, as per I know.
In which year?
Which year? In 2018.
18.
18.
Yes. Yes, thank you. Any question from another?
Yeah, just one question, ma'am. I'll just ask one question, Gayatri. Thanks for the presentation. Gayatri, just your opinion. What do you think, who can do a better job right now in legalizing this same-sex marriage? do you think that the judiciary should intervene and the judiciary should pass a judgment?
So
or do you
I
think the legislature, which is the government, can do a better job? And yeah.
I think judiciary and legislature can do the same better when the same. There are so many things which is happening in India that done by a judiciary, so done by a legislature. So it is we can't compare between them, but I hope that judiciary can also intervene this same-sex marriage problem.
Got it. Thanks, sir.
So I'll call the next presenter. Our next presenter is Lut Lalindliani, research scholar, Effects of Cyber Financial Crime in Indian Society.
Okay, thank you so much, ma'am, moderator. Am I audible?
Yes, you're audible.
Okay. Good afternoon, our resource person, Professor Stuti Deka, ma'am, and Aman Singhania, sir, our moderator, and all the presenters who present the paper today. And I am Ruth Lalindliani. I am a research scholar, and the topic for today's presentation is effect of cyber financial crime in Indian society. First, we will look into the definition of cyber crime. It is one of the most important crime in India today. According to Black laws, it means an evolving area of law that is applied to computer and various activities over the internet and networks. And according to Cambridge Dictionary, the term cybercrime means the crimes that are committed with the use of computer or relating to computer, especially through the internet. So cybercrime, the term cybercrime is a generic term, and it refers to all the criminal activities which is done by using a medium of communication devices, which may include computer, mobile phone, and internet, etc. And we must know that internet is one of the most important elements to commit cybercrime. And cybercrime is differentiated into three major points. And the first one is cybercrime against person. This type of cybercrime includes cyber pornography, cyber stalking, online harassment, cyberbullying, etc. And the next one is cybercrime against property, which includes different types of financial crimes like cheating, credit card fraud, money laundering, etc. And the third point is cybercrime against government. This crime is the least common cybercrime, but this is one of the most important serious offenses. And this is also known as cyber terrorism, which includes hacking government website, military websites, etc. Next, I'll talk about cyber financial crime, which is my main topic. Cybercrime in finance is the act of obtaining financial gain through profit-driven criminal activity, including identity fraud, email and internet fraud, and attempts to steal financial accounts, credit cards, and other payment card information. In other words, financial cybercrime includes activities which as stealing payment card information, gaining access to financial accounts in order to initiate unauthorized transactions, identity fraud, etc. Cyber financial crime or cyber financial fraud is a situation where the victim easily loses his or her money. When he loses his or her money dishonestly through any kind of electronic devices, and different online payment system like UPI method, internet banking system, online mobile banking system, and other online banking system have got a huge rise, not only in India, but also all over the world. So it is easier for the people to practice cashless system in the business activities. But on the other hand, this results in the increasing of cyber financial crime rate every year. So next, I'll go to cyber financial crime in India. India brought its first computer in 1956. Since then, various development in the field of information technology is enormous. To lessen cyber financial crime, the Indian government took important steps in the year 2019 in order to control the rising cyber financial fraud. The government of India, under the guidance of the Ministry of Home Affairs, introduced Indian Cybercrime Coordination Center, which is also known as the 14C scheme. Under this scheme, various centers was established for the identification and investigation of cyber crimes, such as National Cybercrime Reporting, the Platform for Joint Cybercrime Investigation Team, the National Cybercrime Threat Analytic Unit, which is in short known as TAU, and the National Cybercrime Training Center, NCTC, etc. Whenever a cyber financial fraud happens, the victim may report those crime or those incidents by calling 1930. The telephone number is 1930, or lodge a formal complaint on the National Cybercrime Reporting Portal, which is www.cybercrime.gov.in. And the number of complaints reported under the online financial fraud category of the National Cybercrime Reporting Portal from January.
Your 5 minutes are over.
I'll go to my conclusion. Okay. May
You
I?
have 30 seconds.
Okay,
Yeah, you have 30 seconds.
Okay. Cybercrime rates are increasing day by day, and we know that in India we have the Information Technology Act, which is the primary law in India. But we have to know that not only the government, but all of us have a duty and responsibility to combat these crimes to make our society more safe and secure. Thank you. Thank you so much.
Ma'am, shall we proceed?
So my question regarding this, your cyber crime, it is a very common crime that has been committed all over the world. There is no limitation, particular area, in any place, any crime can be committed. So this type of crime can be committed. So you had discussed different types of cyber crimes, and financial aid is your main focus. But regarding to deal with the cyber crime, what law has been is that in India we have the law regarding to deal with the cyber crimes, and what are the measures that has been taken by the government or any person to solve this problem or to minimize the crime?
Okay.
What is your suggestion you have put in your paper? So just give 1 or 2 suggestions and a law.
Thank you so much, ma'am, for your question. And as we know that in India, our parliament has made Information Technology Act 2000. And this act has been amended in the year 2008. But there are lots of loopholes in this Information Technology Act. One of my suggestions is to give more awareness to the people. The people needs more awareness to combat this crime. And regarding those financial crime, the main aim of the criminals are to get money or to gain some profit from the victim of the cyber crime victims. So my suggestion is to create more awareness among the people, those who are, especially those who are in the backward classes, they don't have any awareness regarding that cyber crime. So my suggestion is to make more awareness to the people.
Okay. Any question from Singhania, Mr. Singhania? Thank you. So we can proceed to the next.
Our next presenter is Dr. Pranita Chaudhary, academician, Right to Health and Reproductive Rights of a Woman.
Ma'am, and very good afternoon, sir. Can you hear me?
Yes, yes.
Yes,
Good
ma'am, you're
afternoon.
audible.
Yes. Can you see my presentation, ma'am?
Yes, ma'am.
Yes.
Yes. My topic is right to health and reproductive rights of women. as per the United Nations organization and the WHO, reproductive health is a state of complete physical, mental, and social well-being, not merely the absence of disease or infirmity, but reproduction and sexual health has not been expressed in one single legislation, but we can express it through the right to liberty, right to life, autonomy, privacy, and security of women. Reproductive rights generally mean the right of an individual to control the process of reproduction. It includes the right to decide whether to have a child or not to have a child, or the spacing in between children. Access to these reproductive services are also included here. Considering the importance of human reproduction, reproductive rights have been declared as a fundamental right. These rights are very essential for women to enjoy their human rights. And these rights include prenatal services, safe childbirth, access to contraception. They also include access to legal and safe abortion. Pregnancy and childbirth have always been considered a hazardous journey in the life of a woman, because giving birth to a child is most painful experience in the life of a woman, but the pain and trauma is ignored, and begetting a child is one of the most wonderful and joyous moments in the life of a woman. It's a natural process and a sacred duty, but it is estimated that 1 in every 10 women have pregnancy related complexities. Infertility continues to be a worldwide problem. The health professionals, while caring for such women, have to be very considerate and have to do it in a very holistic manner in this critical juncture of life. Infertility is in the rise nowadays, and it is rapidly, and there are two processes, the ART and the surrogacy, which is gaining importance nowadays in a very rapid way. It is a globally growing industry. Many reproductive clinics are running in the market, and there is possibility of misusing these two technologies, ART and surrogacy, and it is usually commercialized. Artificial reproductive technology is a medical treatment which treats infertility. It is advancing medical technology in which men's sperm and the woman's egg are manipulated artificially in a laboratory outside the human body. The decisions regarding reproduction through art and surrogacy is a personal decision where the government cannot interfere. However, the regulations are mandatory. Now, in 2021, the government has come up with two regulations or two legislations, I can say, which is the Assisted Reproductive Technology Act and the Surrogacy Act. The reproductive rights are protected through various guidelines, national laws, constitutions of the world, regional and international treaties. International statutes like the reproductive rights are human rights has been traced back in 1968 by the International Human Rights Conference held in Tehran. In 1974, in Bucharest World Conference, also in the population conference, that there was a declaration that parents have a fundamental right to decide about their children. In 1975, in the World Conference of Women, which was held in Mexico City also, the same thing was decided. In 1993, the Human Rights Conference in Vienna, 1994 in Cairo, and in 1995 in the Fourth World Conference also in Beijing, it said that there is an plan of action which supports the idea of reproductive right, and reproductive right or artificial or these reproductive rights are human rights. Now, the International Conference of Population and Development, which was held in 1994, achieved a very important milestone in the history of development of reproductive rights, because the core elements of this.
Ma'am, your 5 minutes are over.
Okay. It actually said that the timing of pregnancy and the excess of information, unwarranted interference are certain rights. So there are certain rights which are also guaranteed, or not actually guaranteed, but we can explain it through Articles 14, 15, and 21. So there are certain case laws also which I had, because of paucity of time, I may not be able to explain it, but these are the certain case laws. And the objective of my study highlights, and this is the conclusion.
30 seconds over.
Thank you, sir.
So, Pranita Chaudhary, your topic is right to health and reproductive rights of women.
Yes, ma'am.
So, right to health is a fundamental right, or it is a constitutional right, or what type of right? Right to health.
It is a constitutional right, but although not a specific right to health is not given, but in Article 21 we can say that there is right to guaranteeing health.
Right to health is a fundamental right. Though it is not by judiciary, it is declared as a fundamental right in some cases. But in a legislation, or we do not know that it is a fundamental right.
Yes.
So right to health is a genus, according to me. And whereas your another aspect is a reproductive right, it is a species, is not it?
Yes,
so
yes, ma'am.
Reproductive rights is a right of a woman. A woman have a right to choose whether she can give birth to a child or not to give, or she may take decision for adoption as well as for abolition, or you can say that is abortion of the womb. That is one of the aspect, and that has been decided by the Supreme Court in a very important case law.
Yes,
Very
ma'am.
recently, last year, I think. Just
Yes,
I
ma'am.
forgot the case law.
Yes,
Have
it
you
is the
discussed?
Savita case, who was a dentist and was from an Indian origin, who went to Ireland, and she had complained of complicacy, but the government of Ireland did not allow her to abort because it said that it was a Christian country and not allowing her, and ultimately she had died of such complications, ma'am.
No, that is a different case. But I have discussed a Supreme Court case last year.
It is in Puttaswamy, where it is said that privacy is there.
Puttaswamy?
Yes, ma'am.
No.
Puttaswamy's case.
But anyway, what is your suggestion regarding
Right to
reproductive
privacy?
rights? Yes, that is right to privacy. Puttaswamy case. Yes.
Yes, ma'am. Yes, ma'am.
So every right has been given to the woman, how to see, deal with her reproductive rights and the health right, everything. Is not it?
Yes.
But what is the present position in our society? Can a woman can decide whether she can carry a child or she abort it? What is the present position in our society?
That was what I was going to suggest, ma'am. We want a legislation or a regulation to particularly guarantee reproductive right, which is missing in our legislations.
Yes, your suggestion.
Yes, ma'am.
Thank you. Any question?
Thank you, ma'am.
We'll proceed further. Our next presenter is Indrani Kakoti, research scholar and academician. Her topic is Unveiling Justice, a comprehensive study on victim compensation in POSCO offences.
Good afternoon. Am I audible?
Yes, you're audible.
Good afternoon, everyone. My topic for the presentation is Unveiling Justice, a comprehensive study on victim compensation in POXO offences. Now, with regard to the compensatory jurisprudence that we have come across from it's not that far away. So within the 20th century that we all have started the compensatory jurisprudence, right? Now, the Constitution of India, it guarantees us through its various provisions, through its various articles, starting with Article 21, 38, and Article 51A, which gives us the right of the victims for the compensation. Now, there are certain cases which has been given through Article 21, which from time and again has declared that the rights of the victim to claim compensation is one of the basic human rights, right? starting from the Manju Bhatia case, People's Union for Democratic Rights, People's Union for Democratic Rights as a state of Bihar, to several other cases. Now, with regard to the compensation, with regard to under the criminal jurisprudence, we can see that it has started when the Law Commission in its 41st report has given the scheme of has given the states or the union territories to provide a victim compensation under Section 357 of the CRPC. Now, the 357 CRPC does not provide the amount of compensation that the victims of all crimes could have access to it. Now, one of the the reason for the development of 357, Section 357A of CRPC with regard to the compensation is because unlike the 357 where the victims, they can get compensation only when the accused is convicted with respect to the financial conditions of the accused. Under 357A, the government, with the help of the State Legal Service Authority and the District Legal Service Authority, can award compensation to the victims of crime even though the accused is not convicted or the accused is acquitted. Now, when we come to the victim compensation under the POCSO, now we all know that POCSO is a gender-neutral legislation, and it's been implemented only in 2012. It's not been long enough, but yet we are fighting for the victims of POCSO. Now, there is no specific compensation scheme for the POCSO, the victims of POCSO. Now, and because of which the recent judgment, which was given in Nipun Saxena versus Union of India, where the Supreme Court has stated that, since the NALSA has usually before that have stated that the victims of POCSO that does not come under the victim compensation scheme under the 357A. So because of which in Nipun Saxena case, the court has stated that till the victim compensation scheme with regard to the POCSO offenses it comes, the NALSA should provide the guidelines that has been provided by the NALSA should be followed in every cases of the victims of POCSO. Now, there are certain challenges with regard to the compensation scheme that is under the NALSA and on the victims, the POCSO rule of 2020 that has been enacted now, right? Now, one of the main reasons I would say that it's because of the gender neutrality, which is very distinct in POCSO. But in NALSA scheme, if you see the compensation scheme, it is not a gender neutral one. In fact, when we talk about the victims of POCSO, we are talking about the minor, right? And if you go by the definition of a minor under the victim compensation scheme, which has been given by the NALSA, you would see the minor includes only a girl child below 18 years. Only a girl. So the very objective of the POCSO Act, which talks about, providing a gender neutral legislation, it seems to be diluted, especially when it comes to regarding to the compensation. Are you getting it? Now, also another reason under there are, the drawbacks of the POCSO rules and the schemes, I would say, is that the POCSO rules are not specific enough. There's a confusion with regard to the act and the rules as to who is to, direct the compensation. Now, if we would see, there is a difference between 357A and that of, the POCSO Act. One of the reasons could be the trial court under the Section 357 of 57A, they can only recommend, right? They can only recommend, they cannot direct. But under the POCSO Act, the trial court, that is the special court, they have the authority to direct compensation. They can direct the authority.
Ma'am, your 5 minutes are over.
Yes. Now, these are a few bits of challenges, and one of the interesting, interestingly, there is no particular data when it comes to the compensation that has been received by the victims of POCSO, especially the transgender victims of POCSO. When it comes to the male child, the amount of compensation they receive is quite less. Now, in a study that was conducted in 2019, it has been found that only 4% of victims.
And your 30 seconds are also over.
I'm sorry. So I would like to suggest that that until and unless there is a specific victim compensation scheme for the POCSO offences, the victims will not be given the appropriate right or justice they deserve in due course of time. And since we are following a reparative approach, I think justice can be done only when
Sorry to interrupt, ma'am. Sorry to interrupt, ma'am, but you have to conclude.
Yes, thank you, sir.
Okay, so in this case, you have said that POCSO Act was enacted in 2012, and from 12-13 it was implemented, is that it? So already 10 years is over. So how can you say that it is a very limited period or short period? Within this short period, we cannot say that law has not been properly implemented.
Ma'am, 10 years is not a short duration if you want to talk about implementation. But implementation also plays an equal part, not only with regard to the act, but also with regard to the rules, because the rules lays down the procedures, the guidelines, how to implement the act. And the rules have not been changed, until 2020, the new rules have been amended. Altogether, they have repealed the 2012
Yes,
rule.
yes. The rule has been amended in 2020.
Yes.
2020,
Yes.
it was enacted, I think, framed rule. And NALSA scheme is there. So do you think it is not sufficient to get compensation to the victims of the POCSO Act?
Ma'am, the compensation rule of 2020 that has been laid down, if you see the rule 9 of 2020 rule,
Yes,
it is
yes.
actually verbatim of rule 7 of POCSO rule 2012. So there is nothing changes. They have just changed the rule number, but the ingredients of the rules are almost same. It is verbatim as it is. So there is still confusion with regards to who will decide, because if you go by section 33 clause 8 of the POCSO Act, it's very clear that it's the court who has the authority to decide. But again, if you want to follow the rule which talks about that the compensation has to be provided by the state in collaboration with the state or the district legal service authority under the victim compensation scheme under section 357A. Now, if you want to follow that, then again, the question that arises is the victim compensation scheme under 357A has certain procedures. And that procedure does not give the clear indication as whether the directions that has been given by the
Okay, thank you. So the new rule has to be framed, and the NALSA scheme is also not effective. So scheme has to be changed according to you. Thank you so much.
Thank you, ma'am. Thank you.
I just have one question. Sorry. So you spoke feverishly about the victim compensation scheme and all of that. What is your opinion on victim rehabilitation? In the sense that compensation can be provided for, but how do we ensure? Do you think that the rules cover it adequately, that the victims are rehabilitated, brought back into the society properly?
So that is one of the, I would say this is something that not every legislature, they keep in mind while drafting the rules. They talk about compensation. No doubt compensation plays a very important role in restitutive justice. But the mental state of the victim is quite equally important as that of the physical state. And no amount of compensation could actually rehabilitate the victim until and unless there is a proper scheme of rehabilitation. And the amount of compensation, if we see the rules, the minor victims, they doesn't get all the compensation required. 80% goes to the fixed deposit until and unless it's very urgency. They cannot encash it until and unless they show certain real issues.
Sorry for interruption. Due to paucity of time, we need to cut it short.
I'm very sure, but I would like to suggest a few things with that. Rehabilitation is very essential. I think it should be keep into consideration from the very beginning when the victim approaches the court, and the court, without any hesitant, I think they should appoint a counselor for the victims of POCSO from the very beginning, irrespective of whether the accused has been convicted, acquitted, or has been found at all. I would simply like to say, I think even the POCSO Act should include some part of rehabilitative process towards the victim. Thank you.
Thank you. Thank you.
Thank you.
I'll call our next presenter, Pranami Sharma, academician, legal framework of cryptocurrency in India, issues and challenges.
Good evening, one and all. Am I audible and visible?
Yes, you're audible and visible. Ma'am, you have 5 minutes.
Okay. So my topic for today's presentation is legal framework of cryptocurrencies in India, issues and challenges. So to begin which, I can say that with the advancement of technology, the concept of monetary policies have been revolutionized. And at the same time, the medium of exchange has also been changed. And this is the result of cryptocurrency. So there are various types of cryptocurrencies, among them Bitcoin and Ethereum. These are very famous cryptocurrencies in India. Till now in India, according to the report that is based on United Nations Conference on Trade and Development, 7.3% people, they own cryptocurrencies. By 2030, India is about to exceed UK, US, Russia regarding the cryptocurrencies as well. Cryptocurrencies are considered as virtual currency, as we all know. So this virtual currencies are in encrypted form, and they are different from the normal currencies. In the year 2018, Reserve Bank of India had opposed this use of cryptocurrencies, saying that it can cause risk to the investors. So regarding this, in the year 2018 only, like Internet and Mobile Association of India, that company filed a writ petition against Reserve Bank of India, and finally Supreme Court of India struck down the decision given by Reserve Bank of India, saying that it cannot ban, it should not be banned regarding the use of cryptocurrencies in India. So in the year 2021, one bill was introduced by the government of India regarding the regulation of cryptocurrencies. But till now in India, we do not have the proper legal framework for the cryptocurrencies. There are various types of issues regarding cryptocurrencies. Supposingly, if a person is using cryptocurrency, then in that case, there is no proper well-defined laws, and at the same time there is no proper regulation for this, and sometimes it may lead to that data theft, and for the security purpose also it might lead to problem. So apart from that, there are some challenges as well, whatever I have mentioned in my paper. Challenges are regarding regulation, regarding volatile. The cryptocurrencies are very much volatile, and because of these things, like business personnel, they don't prefer to use cryptocurrencies in India. So as per my opinion, because till now cryptocurrencies is not properly legalized, so as per my opinion, I believe that like for the betterment of the financial positions, or in order to equip with the new generation scenario, we can just start up using these cryptocurrencies in the form of either Bitcoin or Ethereum, so that we can just improve the financial condition of the country. And in the year 2022, it has been focused that due to use of cryptocurrency, we can reduce the tax rate at least to 30%. So as per my opinion, this should be introduced, and it should be a proper law throughout India. Thank you.
So, Pranami, your topic is cryptocurrency. It is a very new topic. Cryptocurrency, it is a digital currency, and it is in a computerized way. It was pro computer network. The currency has been used, isn't it?
Yes,
so,
ma'am.
So there should not be any bank or any other authorities to deal with the cryptocurrency. So do you think in our country, particularly where there is a literacy rate is very low, this currency is good for the people to deal with the money that is cybercrime is always there in India, particularly
Yes.
not in India, all over the world. So cryptocurrency, do you think it is viable in India?
Yes, ma'am. To some extent, I believe that cryptocurrencies will at least try to give a scenario which can be very well known to the people, even though our country is a developing country. Am I audible?
Yes,
Yes, ma'am, you are.
very audible.
Yes, even though our country is a developing country and financially we are not that equipped with other countries, but from my opinion, we should go for the advancement of monetary policies with the help of cryptocurrencies, so that at least we can be well aware about this. And apart from that, if we use cryptocurrencies, then it will be more safe because there is a provision like encryption. That is not possible in case of normal currencies. In case of normal currencies, there is nothing like encryption. So just like ma'am, digital signature, whatever we have under the Cyber Security Act, so similarly we can also have cryptocurrency in coming future.
Okay, thank you, Pranami.
Thank you, ma'am.
We'll move further. Our next presenter is Dr. Shaily Ghosh, Assistant Professor of Law, E-Waste Management and Technological Solutions, a step forward towards achieving the sustainable development goals.
Am I audible, ma'am?
Development goals. Yes, you're
Am I
audible,
audible?
ma'am.
Okay. Good afternoon, one and all. Myself, Dr. Shaily Ghosh. I'm working as an assistant professor of law, and today I would be presenting a paper on e-waste management and technological solution, a step forward towards achieving the sustainable development goals. Today's unsustainable development may lead to tomorrow's concern, because today's electronic gadgets can become tomorrow's electronic waste. So with this statement, I would like to start my presentation. Electronic waste or e-waste has been a worldwide concern in the recent years owing to its escalating amount and accompanying environmental threats. Indiscriminate disposal of used electronic products without abiding by scientific recycling process has shown its lethal consequences. Furthermore, with the increasing consumption of the products, the focus has been more on designs that attract the consumers, which in turn compromises with the durability and support the limitless use of toxic substances. The paper therefore explores the existing struggles in the e-waste management and thereafter deliberate upon the policies, legal instruments, and best practices that has been adopted and that can be adopted for low carbon behavior of the stakeholders involved in the e-waste management. In this regard, I shall also be focusing upon the Sustainable Development Goals and the targets adopted by United Nations Organization in the year 2015 and determine how these goals can help us to set out a roadmap for the achievement of appropriate and effective e-waste management mechanism. So to understand what is electronic waste or e-waste, it can be described as discarded electrical or electronic devices. E-waste can be classified into components, sub-assemblies, and consumables. Components are a group of chemical substances that are part of a larger assembly, but which can be installed and removed separately. Sub-assemblies are the individual parts or components of the larger assembly, and the consumables are items which participate in or are required in the manufacturing process or are in the functioning of the electrical or electronic equipments, which may become the part of the end product or may not become. So these items are substantially or totally consumed during the manufacturing process. Now, the toxic substances that we find in the e-waste are mostly lead, mercury, cadmium, bromine, nickel, and these can cause irreversible damage to the environment as well as human health. It can cause damage to our brain, can cause neurological disorder, can affect human lungs, impair neuronal transmission, can cause lung fibrosis, kidney damage, or cardiovascular diseases, or can even cause cancer at the respiratory tract. Now, some of the sources of the e-waste, they can be generated from the IT and telecom equipments, monitoring and control instruments, the small household appliances like mixers, blenders, or the large household appliances like refrigerator, television,
toys and sport equipments, electronic equipments, switches, and everything. So these are mainly identified as the sources of the e-waste. Now, trying to understand the concern over e-waste, so it is multifaceted and it demands deeper understanding. So first of all, what we see is e-waste are not being recycled in a scientific manner. Mostly in the developing countries, we see that the tons and tons of electronic waste are being dumped and disposed of in landfills and incinerators for a prolonged period of time. Thus, e-waste gets contaminated with water, land, and air, causing irreparable damage to the environment. Secondly, separation of the precious, semi-precious, and rare earth metallic fractions from the electronic materials is something very complex. While we extract the precious fraction, the residue is often left behind, which are not properly recycled. And since they are not properly recycled, we see that they can cause environmental damage. Equally threatening is the exportation of e-waste to developing nations where recycling practices are more often than not compromising with the human health and environment. We see that the attitude of the developed nations is to transfer or to make transboundary movement of the hazardous waste to the developing nations where the compliance rules are quite lenient through illegal ways or even through legal ways. Internationally, we have the Basel Convention in regard to that, but so far as the e-waste is concerned, specifically there is no international law, and therefore the developed countries, they are exploiting the developing nations in this regard. Fourthly, and most importantly, we see that the informal sectors, they play the predominant role in the disposal and recycling process of the e-waste. Now, we see that in the developing nations, the occupation exposures from the e-waste processing are quite lethal. We see that the underpaid men, women, or even children, they are being exposed to the recycling sites where they do not have the
Ma'am, your 5 minutes are over.
Okay, so they do not have the advanced technology by which they can do it, and that is causing health hazard to them. And also our economy is based on planned obsolescence, where we see that the new product designs are promoted every now and then, and that is why the designs are more given priority. Now, looking into the sustainable development goals, though there is no specific sustainable goal on e-waste, but we can look into this particular goals.
Ma'am, your 30 seconds are over.
Okay, so due
Any
to the
question?
paucity of time, these are some of the suggestions that I had made. Okay, thank you so much.
So e-waste management and technological solution. What is the technological solution for e-waste management? So you give us a suggestion you put in your paper. Just tell
Yes,
us.
okay, ma'am, like many so far as the technological part is concerned, we need to have a digitalized approach towards e-waste management. We already have developed, I mean, the law has already developed something called extended producer's responsibility, where not only the producer is responsible during the production of the electronic product, but also it extends till the end of life of the product. So there should be portal where there should be a proper surveillance, and each of the stakeholders, be the producer or the manufacturer, refurbisher, recycler, everybody should register in that portal and should give every details and should mention about the compliance of the rules that are framed. And there should also be the universal standard of rules. As I said, that so far as e-waste management is concerned, there is no universal standard set, and that is why there is a gap between the practice followed in the developed countries and the developing countries. In the developing countries, it is more of the informal sectors who play the predominant role in the recycling. So that has to be formalized. So
suggestion should be very brief and specific.
Yes, ma'am. Yes, ma'am.
So there are some contaminated, that is toxic materials are there in e-waste. You have already discussed in your paper. So some materials, lead, mercury, cadmium, etc., arsenic is also there. So these are the particles that affect the health of the people. It's not it?
Yes. Yes, ma'am.
how to deal with that aspect, that is sustainable development. Regarding sustainable development, what are the methods that has been introduced by the government of India, or what are the rules that has been framed by the government of India for e-waste
Firstly,
management?
okay, sure, ma'am. Firstly, the thing is we have to minimize on the use of the toxic substances, and we should concentrate more on the durability of the substance rather than improvising on the designs or anything. We should try to ensure that more durable substances are used and which are less affecting the health of the people and less use of the toxic substances. And it is also important that every stakeholder in this whole process, they comply with the strict regulatory mechanism that
Okay,
is.
thank you. Thank you. Time is.
Okay, ma'am.
Okay, thank you.
Thank you so much.
I would like to call our next presenter, Deepam Jyoti Das, advocate. Free legal aid in Indian Constitution and analyze.
Am I audible or visible, ma'am?
Yes.
Is my slide, is my PPT has been shown in, ma'am?
No,
I
your
have shared my PPT.
Is
no,
it visible?
PPT is not visible. Yes. Yes, now visible.
Yes, we can see now.
Very good afternoon to all, respected resource person, Honorable Stuti Deka ma'am, former HOD of PG Department of Guwahati University, and respected Aman Singhania sir, Advocate of Supreme Court, and all the learned participant present here. My presentation topic is free legal aid in Indian Constitution and analysis. And I would like to start my presentation with the quotation of Justice Harry Blackman, who said, the concept of seeking justice cannot be equated with value of dollars. That means justice cannot be obtained through the use of money. As we all know that India is a country where majority of the people are poor and illiterate, and they don't know about their rights. And if they know about their rights, they are unable to afford the court or advocate fees to get justice. In the year of 1976, by 42nd Amendment, a specific article has been added, that is Article 39A, Directive Principle of State Policy. And now I'm going to say what is legal aid. In layman terms, legal aid means granting free legal service to the person who are economically poor and who are economically weak and who are unable to afford advocate and court fees. The main objective of my study is to know about how far the provision of the legal aid taking care of the need of the needy people, and how far the provision of the legal aid meet the end of justice, as justice should not only be done, it seems to be done. And how far the provision of the legal aid, whether it is properly implemented or not. Though my study is totally purely a doctrinal one, but I have met various Secretary of District Legal Service Authority. Now I am going to say about the various provision of free legal aid under the Constitution of India. In Article 14, it provides that everyone should be treated equally, equality before the law, irrespective of caste, sex, place of birth, etc. In Article 21, it provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. In Article 22, subclause 1, it provides that if a person is arrested or detained in police custody, they have the right to know about their cause of detention, and they have the right to choose an advocate of their own choice. In Article 39A, it provides that equal justice and free legal aid to weaker section of the society. And in the year of 1987, the Legal Service Authority Act has been enacted, and there are three authorities. One is National Legal Service Authority in central level, one is State Legal Service Authority in state level, and one is in every district there is District Legal Service Authority. And now I'm going to discuss about the role and contribution of judiciary in developing the concept of free legal aid in India. In this regard, Justice P.N. Bhagwati and Justice Krishna Iyer plays a prominent role in developing the concept of legal aid in India. At the very outset, I would like to discuss the fact of the Husainara Khatun versus State of Bihar. In this case, a number of untried prisoners were kept in various jails of Bihar. The court ordered immediate release of them, and it was held that speedy trial is an essential part of fundamental rights, and free legal aid is also an essential part of fundamental rights. In the case of State of Haryana versus Darshana Devi, in this case, it was held that no poor should be deprived of justice market due to their financial condition. In the case of Khatri versus State of Bihar, in this case, Justice P.N. Bhagwati held that in every district and session court, district and session judge has to be informed to the accused regarding the free legal aid service if they are unable to afford the court service. In the case of Sukdas versus Union Territory of Arunachal Pradesh, in this case also a landmark judgment has been provided by Justice P.N. Bhagwati.
So your 5 minutes are over.
Okay. Now I'm going to provide the issue and challenges in very few words. What issue?
Last 30 seconds.
Okay. What issue and challenges I have got in my study that district level service authority has not been properly facilitated to perform their functions, and poverty, illiteracy, and ignorance are the main cause for which the aim and goal of free legal aid benefit is not properly implemented. And what I want to provide suggestion that local language is more convenient to create awareness. So some print materials, some legal
30 seconds are over.
Should be circulated. Okay, I want to conclude. Okay, thank you.
Ma'am, question.
Okay. So my question is regarding free legal aid. Who is eligible to get free legal aid? Very simple question.
Generally, free legal aid under the Section 12 of Legal Service Authorities Act, there are certain criteria has been mentioned. The criteria has been varied to state. In case of Assam, though are economically poor, that is below their annual income is below 3 lakhs, they can avail the service of free legal aid.
Below poverty line, BPL, the persons who are below poverty line or anybody. So my next question, in Article 39A, that is a legal provisions, constitutional provision. It is a directive principle of state policy. Is that it? Or it is a fundamental right?
Yeah, is it a fundamental rights? No,
fundamental right.
Sorry, ma'am, I unable to understand.
What is the article that deal with free legal aid?
Article 39A.
39A.
Directive principle of state policy.
Yes. So whether it is a fundamental right or it is a directive principle of state policy.
Article 39A is a directive principle of state policy.
So
but there are a few provisions in fundamental rights also. Just Article 22 subclause 1 and Article 21. These are also provisions for which.
Ma'am, we need to cut short.
Okay. Thank you, Deepak.
Thank you.
So
Our next presenter is Garuku Sri Ashish Reddy and Dr. KVSM Kamasai, student professional. Their topic is efficacy of alternate dispute resolution vis-a-vis resolution of disputes.
Madam, good afternoon. Am I audible?
Yes,
Yes, you're audible.
Well, thank you so much, madam.
So you have 5 minutes.
Shall I start?
Yes, sir.
Esteemed Professor Stuti Dekar Madam,
Yes, sir.
Aman Singhania ji, and all organizers of this grand national conference. At the outset, I would like to convey my thanks to the organizers for giving me an opportunity to participate in this spectacular event. Succinctly, the crux of my presentation is the role and importance of ADR in the settlement of family disputes. As all of us know, India is known for our ancient and rich cultural and spiritual heritage. India is one, might be, I can proudly say, only country in the world where the family is attributed spiritual, social, cultural, and emotional significance. The tie among the family members between the spouses, between the parents and children, and their lineage is in fact breaks a fresh ground, stands totally on a different footing when compared to the other social backgrounds anywhere in the world. Now, with regard to the matrimonial ties, which is the crux of my present paper, the importance of the ADR and the family disputes. Ours is the country which in fact has believed that marriage is a sacrament, marriage is not a consensual civil contract. Once man and women have been brought together, bringing about the spousal relationship, that matrimonial tie is presumed to be eternal, everlasting, not only in this temporal world, but also in the extemporal world. At the same time, for the many future births to come. So that is one aspect. So now, with this rich social and cultural background reflected in our ancient customary personal laws, Shrutis and Smritis, now in this contemporary world, we are very much aware how from time to time the family disputes, more so among the spouses, are escalating beyond imagination. Of course, we can't deny, we can't restrict altogether that there will be and there should be no dispute between the spouses. Once the dispute crops up and reaches the climax, it is a common experience all over the world, for which India no spouses in a family are an exception, that they approach the court for resolution of their family dispute or matrimonial dispute, most likely the dissolution of the marriage. But here, as we know, the change is law of nature, for which the legal framework also is bound to undergo the impact of change. So therefore, what I would like to emphasize in this background is the present judicial mechanism.
So your 5 minutes are over. Last
Sorry?
30 seconds. Your 5 minutes are over.
Thirdly, adopt a flexible and friendly approach to the parties in a matrimonial dispute and refer the matter to the alternate dispute resolution mechanism. One suggestion I would like to make is that the matrimonial, the courts vested with the family jurisdiction over the family disputes must be directed. Must be made mandatory to
So your
refer.
30 seconds are over.
Well, thank you, but to refer the disputes to the ADR mechanism. Thank you so much.
Ma'am, any question?
No question, please.
Thank you, ma'am.
We'll move forward. Our next presenter is Pungyaj Pratap Bordoloi. He is a research scholar. His topic is Human Organ Transplantation Act 1994, Legal and Ethical Issues.
A very good evening to everyone. Am I audible, ma'am?
Yes.
Yes, you're audible.
A very good evening to Honorable Stuti Dekar ma'am, to Singhania sir, to Advocate Shivangi Goyal, and all the other learned participants present today. As per my topic has been already been introduced by Advocate Shivangi Goyal, I would just like to bring forward that with modern medical features and technologies, men have become a help to one another. On a certain perspective, or a very last perspective actually, to save life. Among all of this, one is transplantation of human organs from one person to another. But while in the process of doing such an act, of such a noble act, it has been seen a high rise of black market, wherein organs of the poor people are being taken to serve to the richer class of the people, to make sure that such an black market or such an evil thing is not done in the society. An act was introduced in 1994. The act, name of the act was the transplantation of the transplantation of human organs, 1994. In this particular act, many limitations were seen, many limitations were given, just to make it sure that any kind of black market or any kind of evil that was happening in the society should be stopped. One of the biggest problems while enacting this act was Section 22, whereby this section gives pressurized that it forbids from taking any cognizance offense. That means whenever there is a crime that has taken place, there is no investigating agency to take cognizance unless and until a third party have come forward to give a complaint. There has been seen, there is no medical reports of any hospital, any doctors, or any medical fraternity that how much actually is a transplantation of any human organ from one person to another person has been taken place. Because of such an evil act, it was been done during this act that no person can donate one organ to another unless and until the donor belongs from his own blood group, or sorry, his own blood relative. So it was very strict on that particular moment of this particular act. But in one of the cases where it has become a landmark, in a case of Arup Kumar Das was a state of Orissa, where it was seen very specifically that Arup Kumar Das was suffering from a kidney failure. But because of this act, it was not possible for him, as none of this blood relative was able to give any part of the kidney to him to save him. Finally, Arup Kumar Das was very fortunate that he got a same blood group, same everything with one of his friend. But because of this act, his friend was not been able to help him to give his kidney to him. Now Arup Kumar Das went over to Supreme Court regarding this case. The Supreme Court came down after hearing both the parties, the authorities as well as Arup Kumar Das, that it is possible for a person to donate any organ to another person only on this consent or on his own empathy. But there cannot be any regulation or amendment on this particular case. What my suggestion would be regarding this particular act is that Section 22, which prohibits any agency to take up cognizance, should be afflicted or should be given a certain amount of flexibility. or even, if possible, a very particular investigating agency should be brought forward so that they are only dealing with this kind of crimes. With this, ma'am, I would like to conclude. If any questions are arising, ma'am.
Human Organ Transplantation Act 1994. So
yes,
we
ma'am.
have discussed 1994 Act. After
Yes,
that
ma'am.
Act, what is the amendment of that particular Act and why the amendment has been made?
Ma'am, the amendment was mainly made on 2003, but it was seen that though these amendments were made, the main
2000,
amendment
2000, yes, yes. 2000 in which year?
3, ma'am.
Latest?
Ma'am, I believe the last time I saw it was 2003. If any, I had to
No,
go
no,
through
it
that.
is 2011.
2011, sorry, ma'am, sorry, ma'am. 2011, because I also have a case of 2013 where
Yes.
Mrs. Indira Beheru was the state of Orissa was also there. I'm sorry, ma'am. 2011,
Okay.
this amendment, ma'am. Because I remember this Indira Beheru was the state of Orissa. Yes, ma'am. Regarding the amendment, it was seen that not actually amendment, but the same thing which I said earlier, that any blood relative, if it is not possible, then can also give or donate, but the consent and the empathy should be present during that.
Tuti ma'am?
I believe there must be a technical glitch, ma'am.
Tuti ma'am?
Should I end up, ma'am? Advocate Shivangi Goel? Okay, thank you.
Yeah, thank you so much.
Thank you so much. Thank you.
Due to some technical issues, Stuti ma'am is not with us now. We'll move forward. And our next presenter is Tanushri Bhattacharjee. She is a research scholar. Her topic is Role of Judiciary for the Protection of Wildlife in India, a study. Ma'am, you have 5 minutes.
Yes, good afternoon, everyone. Am I audible?
Yes, you're audible.
Okay. Wildlife is essentially classified into flora and fauna, which mean, in a broad sense of speaking, plants and animals respectively. The Government of India has allotted vast spaces of green forest of wildlife to flourish in. Several protected lands are declared as wildlife sanctuaries, national parks and biosphere reserves meant for the sole purpose of protecting wildlife against human interference. Several non-governmental bodies have stepped up to the demands of wildlife conservation in India as well. Wildlife conservation in India has a long history, dating back to the colonial period, when it was rather very restrictive to only targeted species, and that too in a defined geographical area. Then the formation of the Wildlife Board at the national level and enactment of Wildlife Act in 1972 laid the foundation of present day wildlife conservation era in post-independent India. Henceforth, the Act has been amended several times, and the National Wildlife Advisory Board has undergone various changes. Project Tiger in the year 1970s and the Project Elephant in 1992, both with flagship species, attracted global attention. Constitutional provision for the protection of wildlife. The Indian Constitution became one of the rare constitutions of the world where specific provisions were incorporated in the Suprema Lex, putting obligation on the state as well as the citizen to protect and improve the environment. This is certainly a positive development of Indian law. The state cannot treat the obligations of protecting and improving the environment as mere pious obligation. The directive principles are not mere showpieces in the window dressing. They are fundamental in the governance of the country, and they, being part of the supreme law of the land, have to be implemented. Article 37 of the Constitution provides The provision contained in this part 4, shall not be enforceable by the court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Next is legislative provisions for wildlife protection. From pre-independent period to till date, India has various enacted laws for the protection of wild animal and forest. After independence, many more laws passed by the Legislative Assembly for the protection of environment as well as for the protection of wildlife and forest. Those are the Wildlife Protection Act 1972, Cruelty to Animals Act 1860, Environment Protection Act 1986, the Forest Act 1927, and the Prevention of Cruelty to Animals Pet Shop Rule 2018, Biological Diversity Act 2002. Role of judiciary for protection of wildlife. Enactment of law but tolerating its infringement is worse than not enacting a law at all. Continued tolerance of such violation of law not only renders legal provisions nugatory, but such a tolerance by the enforcement machinery encourages lawlessness and adoption of means which cannot or ought not to be tolerated in any civilized society. A law is usually enacted because the legislature feels that it is necessary. It is with a view to protect and preserve the environment and save it for future generation and to ensure good quality of life that the legislature has enacted and anti-pollution laws and incorporated many statutory provisions for the protection of the environment. Now I want to discuss some case laws. First case is Forest Friendly Campus Private Limited versus State of Rajasthan. The court held that non-mentioning of the name of the village in the notification cannot be a ground for quashing and notification, as this mistake were corrected and boundaries were specifically given in the subsequent notice, and further orders were passed after examining claims and objections of the interested persons villages. Next case is T.N. Govindram Tirumalpat case. The recommendations made by the Central Empowered Committee containing directions for demolition of all fish tanks constitute illegally by encroachment inside the Koleru Wildlife Sanctuary and prohibiting use or transportation of imputes for fishiculture in the said sanctuary were in question.
Yes.
Ma'am, would you like to ask any question to our previous speaker?
No, it's our Punya Patak Bordula. Yes.
Yes, ma'am.
Okay.
Ma'am, would you
thank
like to ask any question to Tanushree?
Regarding?
Her topic is role of judiciary for the protection of wildlife in India, a study.
So,
No questions from my side. Sorry.
okay, I have just only one question. NTCA. What is the full form of NTCA? It is a protection of wildlife related to protection of wildlife. That is, the act was enacted first in 1972. Then it was enacted into amended in 2006. So
Wildlife Protection Act.
Yes, Wildlife Protection Act.
1972. You were talking about it.
Yes. No, it is an original act, but it was amended in 2006. In 2006, there is a chapter incorporated in the act, that is amended act. And in that act, there is a provision, NTCA. Do you know what is NTCA? If yes, okay, otherwise.
No, ma'am. I can't recollect at this moment.
So it is National Tiger Conservation Authority, NTCA. So
Okay,
that
ma'am.
the separate provision has been incorporated in the act. Anyway, thank you.
Okay, thank you, ma'am.
Okay.
So our last presenter for today is Dr. Pratik Gharami. He is an academician. His topic is rule of law and its applicability in contemporary society and analytical studies.
Good morning, everyone. I am Dr. Pratik Gharami, an assistant professor. My topic is rule of law and its applicability in contemporary society and analytical study. One of the basic principles of the English Constitution is the rule of law. This doctrine is accepted not only in the Constitution of USA, but also in India. According to Black Law Dictionary, rule of law means legal principle of day-to-day application approved by the authorities and expressed in the form of logical proposition. According to Dicey, one of the cardinal principles of the English legal system is rule of law. There are three meanings of the doctrine, that is, supremacy of law, equality before law, and predominance of legal spirit. According to Dicey, rule of law means the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power or wide discretionary power. On the part of government, it includes the existence of arbitrariness, of prerogative power, or even wide discretionary authority. Dicey says that there must be equality before the law or equal subjection of all classes to the ordinary law of the land, which has been administered by the ordinary law courts. He maintained all persons were subject to one and the same law in England. Dicey says that in England, the general principles of the Constitution are the result of judicial decision of the court. The rights are guaranteed by written constitution in many countries, but in England, it is not so. The rule of law is an ancient ideal. It has been first posited by Aristotle, a Greek scholar, as a system of rules inherent in natural order. Rule of law began around 1215 in England when King John signed the Magna Carta. The signing of Magna Carta indicated that the consent of the monarch of England to be under the law. After the conflict between the parliament and monarch, the doctrine of the rule of law in England took a new look. In 1776, the doctrine of rule of law was first introduced in United States of America by the constitutional lawyer known as Paine. There are several principles of the rule of law which law and policymaker, judges, and law enforcement agency should consider while exercising authority in a democratic society. This means, according with the law, all duties, power, and function of the government, including its organ and duties, have done. The rule of law has been propounded by Indian philosophers in their own way, such as Chanakya, by maintaining that kings should be governed by the word of law. The concept of rule of law is that the state is governed by the law, not by the ruler or the representative of the people. In modern democratic country, a number of exceptions has been engrafted on the idea of rule of law provided by Dicey. In India, Dicey's concept of rule of law cannot be said to be followed in strict sense. There are some exceptions which have been provided under the Indian Constitution and other laws. The wide discretionary power in relation to certain matters under the Indian Constitution have been given to President of our country and Governor of the state. Under the provision of Article 72 and 161 of the Indian Constitution, the President and the Governor respectively have power to grant pardon, respite, or remission of punishment, or to suspend, remit, or commute the sentence of any person who has committed any offense. Under the provision of Article 14 of the Indian Constitution, there is equality before law and equal protection of law among the citizens. The equal before the law does not mean like public official, private party will claim same benefit. There are many power, immunities, and privileges of public officer like minister, local authority, public officer, but not ordinary citizen. In discharge of executive function, the president or governor was not answerable to the court of law. When president or governor is in office, no criminal proceeding will be instituted. On the theme of rule of law in a free society, the International Commission of Jurists had organized an international congress of jurists in New Delhi in 1959. In Congress, more than 185 judges, lawyers, and law professors had participated. To promote the rule of
Sir, your
law,
5 minutes are over.
a pledge
Ma'am,
was
any
taken in
question?
the area of legislative, executive, and criminal process and the judiciary.
No question.
Thank you, sir.
Okay, ma'am.
Stuti ma'am, Aman sir, any questions, any suggestions?
No, I don't want to ask any questions regarding rule of law. So, if it is
Nothing from me
compulsory,
either.
then I can ask one question. So, whether natural justice is included in the rule of law?
Yes, ma'am.
Natural justice is included in a rule of law?
Natural justice is included in rule of law. Yes, madam, but there are some exceptions.
What are the exceptions?
But natural justice means no party should be condemned unheard, and both parties will be given same chance to express his opinion. But the president or governor is not answerable for taking any activities.
Okay,
Thank you, sir. Thank you, Stuti ma'am. Thank you, Aman sir, for joining the session with us.
So, in the conclusion, thank you all. Thank you, Ms. Goyal, Advocate Ms. Goyal, and Singhania, Mr. Singhania, and all the organizing committee for giving us this opportunity to join as a resource person in this conference, national conference. Thank you all. Thank you very much.
Thank you, ma'am.
Okay, ma'am. Thank you.
Thank you so much, everyone. Thanks a lot.
Thank you, Aman sir.
ये सब क्या है यहाँ से काट कर
Has the resource persons for the session have joined? Just check, Deepshika Martin.
Yes, sir. Yes, sir. I'm here. Dr. Hina Kaushal.
Has Dr. Pyali Chatterjee ma'am joined? Wait a second, I'll just text her.
She's yet to join. She has not joined.
Yes, just texted her. She'll be joining in a minute because we still have a minute to go for the session. So let's give them a liberty of 1 minute.
Okay.
So the second resource person for the resource person for the session has just joined. So with the permission of the resource person, can we begin, ma'am?
Please go
Yes,
ahead,
sir, you
sir.
can begin.
Yes, ma'am.
A very good evening, everyone, respected resource person and my dear participant. I, Deepshikha Das, the moderator for this session, welcome you all to the National Conference on Emerging Contours of Law and Justice in the Contemporary Era, Issue and Challenges, organized by PG Department of Law, Guwahati University, Assam, India, and Gerard Prenell Group, a unit of Arjun Das Gulati Memorial Society, Prayagraj, in collaboration with Guru Angad Dev Teaching Learning Center, Pandit Madan Mohan Malviya National Mission on Teachers and Teaching, Ministry of Education, Government of India. Proceeding further, I would like to welcome our respected resource person for today's session, Dr. Pyali Chatterjee, Head of Department Faculty of Law, IFA University, Raipur, Dr. Hina Kaushal, Assistant Professor Law, Reva University, Bangalore. Before starting with the session, I just want to inform all the participants that you will be given 5 minutes each for presentation, and you will be getting reminder after 3 minutes are over, and after 5 minutes are over. Ma'am, with your permission, shall we start?
Yeah, ma'am, you can start.
Okay. At the very first, I would like to invite our first participant, Rumi Roy, academician, title of paper, Constitutional Morality in India's Vibrant Judiciary, Dr. Ambedkar Vision and Judicial Perspective in Post-Colonial Indian Society. Ma'am, over to you.
Thank you, ma'am. Good evening, Chair, and good evening, all the participants present over here. So my paper, as ma'am has already outlined, Constitutional Morality in India's Vibrant Judiciary, Dr. Ambedkar's Vision, and Judicial Perspectives in the Post-Colonial Indian Society. So this paper examines the understanding of how constitutional morality as envisioned by Dr. B.R. Ambedkar has been put into practice and has been used. Because when we talk about constitutional morality, it is not just a recent phenomena or it is a recent concept. It emerged in the Constituent Assembly debates, when the drafting of the Assembly was taken. So this paper has been an attempt to understand and to pin down the principles on what part of constitutional morality is put into practice in the judicial pronouncement in the post-colonial Indian society. So very quickly, I would give a brief idea about how the concept has come and how it has been put into practice in the judicial pronouncement. So therefore, this study that holds the prospect that judiciary should outline the constitutional morality as the basis, that is the finding, that constitutional morality as the morality which must have Dr. Ambedkar's, that is the chairman of the drafting committee, social philosophy, that is liberty, equality, and fraternity. So what is constitutional morality actually? So when we talk about constitutional morality, basically talks about an adherence to the core principles of the constitution in a democracy. So it is not just limited to the constitutional provision just to in a literal sense of a term, but in order to make a democracy more collective, it has to be more inclusive, it has to be more democratic. So it can be understood as some sort of a standard or some sort of a behavior from the people of the country within the constitutional institutes, and that by imposing at the same time certain standards to be imposing upon the authorities in the administrative action and the line of the administrative actions that ensure with the operation of the constitutional laws. And that is what our founding fathers, when the concept of constitutional morality was envisioned, they believe that the constitutional law should be inconsistent with the fundamental ideals and values of the constitutions. Although if you read the constitution, nowhere in the constitution it has been definitely defined. You will find the practice of constitutional morality when you refer to part 3 of the Indian Constitution, that is the fundamental rights, the directive principles of state policy 51A. But as a principle, it is nowhere to be defined and delineated in the Indian Constitution. So it is subjective to the interpretation of the judicial luminaries when it comes to the practice of constitutional morality, as we have seen over the years from the drafting of the Constituent Assembly till present. And when we talk about the concept of constitutional morality as been envisioned by
Ma'am, your 3 minutes are over.
Dr. Ambedkar, he has been influenced by George Grote, that is the classicist, who wrote about the history of Greece, and he talked about how democracy has come to be practiced. So quickly coming, to how constitutional morality has been come into practice, we know that when we talk about the Indian judiciary, it is a vibrant judiciary, and its high officials, they have, in addition to their traditional loads, they have been propagating progressive ideas and philosophy in line with the demands of the society. So constitutional morality is like a new addition in line to the traditional role which the judges, in which the judicial pronouncements have been made. So it has become an inherent part of. If we see, 2 decades of constitution history, the word was first used in Keshwananda Bharti versus the state of Kerala, then S.P. Gupta versus the Union of India, where constitutional morality was considered, the Constitutional Convention would be considered as a violation of constitutional morality. And one of the most landmark judgments in which constitutional morality has been put into practice is the Government of NCT of Delhi versus the Union of India, in which constitutional morality, Chief Justice of India, Deepak Mishra, said that it is the second basic principle structure. So the basic principle structure, which is itself subjective to the interpretation of the judges. Here, in fact, the constitutional morality has been laid as the second basic principle, yet subject to the interpretation of the judges. So here, again, in Supreme Court, in the S.K. Kaushal versus Suresh Kumar Kaushal versus Now's Foundation 2014, morality as the good basis for rejecting, this was a very landmark judgment, because again, in Navtej Singh Johar versus Union of India, constitutional morality has been invoked once again. So apart from this judicial pronouncements, what did, in a nutshell, if we see the performance of the judiciary, it can be said that in the decisions of the Supreme Court, constitutional morality has
Ma'am, your 5 minutes are over.
Abided by the postulates of human liberty, equality, and fraternity, in line of what Ambedkar's philosophy or Ambedkar talked about. Thank you so much.
Thank you, ma'am. Ma'am, would you like to question?
No, she has well presented her paper, so I had no question. But yeah, Rumi, I just want to know that if you have to explain this constitutional morality as a layman, how will you explain it?
Ma'am, it is like the adherence to the basic principles of liberty, equality, fraternity, in which Ambedkar has not only talked about, just political liberty, but as well as social and economic liberty of the people as well.
Okay, thank you, ma'am. Moving further, our next participant, H.R. Lal Raman Gakhi, research scholar, title of the paper, The Law of Sedition and the Freedom of the Press, a study on the need for media plurality in exercising freedom of speech and expression in India. H.R. Lal Raman Gakhi. Okay, moving next, Aisha Siddiqui and Dr. Kamsai SBM, Student Associate Professor, title of paper, From Ink to Pixels, Evolution of Censorship and Freedom of Expression.
Good evening. I'm Aisha Siddika. I am associated with my professor, Dr. Kamasai. I'm from Yale University, currently pursuing my 5th year of BBA LLB. Today, my topic is about from inks to pixels, evolution of censorship and freedom of expression. So transition from the print media to the digital media, there was a profound evolution in the landscape of freedom of speech and expression. The transformation has brought forth the challenges and opportunities that reshape the way society perceives and exercise both censorship and the right to express oneself. In the historical content of the print media, government and authorities controlled content in the newspapers, books, magazines to shape narratives, suppressing dissenting voices and manipulate public opinion. Though this era has been controlled by the governments and authorities, this era also witnessed creativity of the creative techniques, methods, such as encryptions and allegories, to bypass the censorship and convey hidden messages. At the same time, underground press also emerged as a response to disseminate uncensored ideas. With the rise of the internet and digital media, a new dimension emerged in the struggle for freedom of expression. The global reach for the internet allowed individuals to share their thoughts on a global scale, breaking traditions, communication barriers. However, these era also brought challenges like censorship evasion, surveillance concerns, information overload, and the rise of harmful content. The influence of social media platforms amplified individual voices, but also introduced concern about hate speech and online harassment, which led to the self-censorship. Governments respond to the digital media landscape with various regulatory measures, raising debates about the balance between freedom of expression and the need to regulate harmful content. The responsibility of the online platforms in shaping public disclosure becomes a focal point of the discussion. Through this journey from inks to pixels, the core principle of freedom of expression have remained a driving force, reflecting the ever-shifting dynamics of society and technology. The evolution of censorship and freedom of expression continues to influence discussions surrounding media, culture, democracy, the responsible use of the digital platforms. Thank you.
Okay, thank you. Ma'am, would you like to question?
No, Aisha, though it looked good to see a graduation student while presenting her paper, you have done really well. But yeah, it's a suggestion to use Aisha. I don't know whether it's the first time you are presenting a paper.
Yes, ma'am.
But yeah, still you have done very well. So from next time, whenever you are presenting your paper, don't read it. You have done the research, you know about the paper. Just speak it from your heart. Whatever you know, just speak it. Don't read it. Okay? And rest you have done very well. You have done nice presentation.
Thank you.
God bless you and all the best for your future.
Thank you.
Okay, moving to next, I would like to welcome HR Lal Raman Gakhi, research scholar. Title of paper, The Law of Sedition and the Freedom of the Press, a study on the need for media plurality in exercising freedom of speech and expression in India. Ma'am, over to you. Ma'am, please unmute.
I see sending message, I think. I am unmuted.
But ma'am, we are unable to hear you.
You do one thing, you have joined through your mobile or laptop? Just message, if you have joined through your laptop now, do one, you just join from your mobile. You join from your mobile.
Okay, ma'am, then moving to the next. I would like to welcome Ramni Sachin Hangir-Gekar, student. Title of the paper, Contemporary India, Indian Legal Framework for Regulation of Online Gaming Analyzing. Ramni Sachin. I guess it's not there.
I think HR. I think CS joined.
HR Lal Raman
Yeah.
Gakhi, can you continue?
Unmute yourself. Yeah.
Yeah. Okay. Over to you, ma'am.
I think still CS problem.
Ma'am, you can start your paper. Ma'am, I would suggest you to leave the meeting and again join the meeting. Okay, thank you. Moving to next is our next participant, Sumitra Devi and Kankana Chaudhary, academician, title of paper, Media and Entertainment Laws, Emerging Trends and Issues. Sumitra Devi. Kankana Chaudhary.
Next one, ma'am.
Okay, the next one is Debashrita Manik and Vibhu Kaibalya Manik, student and assistant professor. Title of the paper is Role of Media in Shaping the Society, Issue and Challenges in Legislative Framework.
Good evening, ma'am. Am I audible?
Yes.
Ma'am, I would like to share my PPT over here. Hello.
Yeah, sure.
My topic is role of media in shaping the society, issues and challenges in the legislative framework. Myself, Debashrita Manik, and I am a fourth-year law student from Kids School of Law, Bhubaneswar, Odisha. Coming to the introduction of my paper, so as we all know, media and press industry is often considered to be the third eye or to be the fourth eye, and fourth pillar of democracy after the legislative, executive, and judiciary, and it is said to be the voice of the voiceless. And of course, free, vigorous reporting, constructive criticism, and debates regarding certain hot and current affairs has a huge contribution in the understanding of a rule of law and the concept of the entire justice system. The Constitution of India, that is the supreme law of the country, has awarded us with 6 fundamental rights, out of which one is right to freedom of speech and expression. And the freedom of press and media, as upheld by the Honorable Supreme Court in the case of Ramesh Tomar and State of Madras, which is a 1950s case, has also included that freedom of press and media is covered under the ambit of right to freedom of expression and speech. The freedom of speech and expression has also certain reasonable restrictions to it, as stated under Article 19, Clause 2, that says that the Government of India and the Court of Law can also impose reasonable restrictions on the freedom of speech and expression with respect to sovereignty and integrity of India, security of the state, contempt of court, defamation, and many more. Coming forward to the second slide, I have focused on issues and challenges faced by the media and press. We all know how agonizing the media trial can be. With the help of various cases, I have tried to mention that. As we can see, the Sanjay Dutt case is there. We all know back in 2013, Sanjay Dutt was booked by TADA, and the media coverage was in such an extent that Sanjay Dutt was shown as a terrorist to all the citizens of India, keeping his acting career of such a great Bollywood star at stake. But however, after several proceedings, it was clear that Sanjay Dutt was not a terrorist, but however, he was booked by Tada for keeping AK-546 rifles at home without any license. And next is Manu Sharma versus NCT of Delhi, which is also known as the Jessica Lal murder case. Here, the media coverage acted in such a way that the public pressure and media coverage even compelled the justice system to give a second thought to the judgment that was passed. And Manu Sharma was acquitted. But later he was sentenced for life imprisonment. And a case study of Aryan Khan, who is the son of famous Bollywood actor Shah Rukh Khan, he was also dragged by the media trial, saying that he was involved in the drug case. But however, the Narcotics Control Bureau also helped him.
Ma'am, your 3 minutes are over.
Sure. By saying that he was a clean guy and had no records in the drug case. Another such issue is the paid news. It is often talk of the hour that the media houses and journalists get paid to air and broadcast or even write or publish about such a topic, or about such a topic which is very current or very entertaining to our ears. But that is not the reality. Instead of being free and fair, they telecast only those things which will be helping them to gain their TRPs and increase the value. Last but not the least, my next issue is selective narration of facts. Now, selective narration of facts is another challenge where I would take an example to explain the situation. Where back when India had one of its most terrific and horrific terrorist attacks in Mumbai, 26/11, the terrorists took the decision of their next move and planning for their next execution of attack only after looking at the national television's news or reading the newspaper articles. And they only planned their execution only after reading the news that covered the strategies of the police department and the government of India. Now, that is also one of the biggest challenges that I have seen. And coming forward to the conclusion, media houses and newspapers often follow the principle of indoctrination of propaganda, which precisely refers to wrongfully imposing one-sided thoughts into the minds of the people by telecasting, airing, or writing about one side of the story instead of being free and fair and acting as a natural body. With this, I would like to conclude by saying that there is a strong lacuna for the there's a strong lacuna and no provisions.
And your 5 minutes are over.
Okay, I'll just conclude by saying this.
Yeah, sure.
There is a strong lacuna of a strong codified legislation for the proper utilization and working of the media and entertainment and press. And since there is no law, no statute, and no provision that apart from defamation to control and regulate the media and journalism, the media houses as well as the newspapers enjoy their monopoly at large. However, if imposition of punishment and is there on spreading of fake news would not only help the netizens to remove the blindfold and see the reality, but also keep the journalists and media houses at control. Thank you.
Devasrita, I had a question relating to your presentation. Because as we all know about the media trial, issues relating to media trial, okay? And as now you have quoted about the Sanjay Dutt case also, Aryan case also you have quoted here. So don't you think that there is a strict, legal provision to tackle such kind of media trial in India? Because recently we have seen that media trial has been increased nowadays. And we generally, being media as a fourth pillar of a democracy, we generally believe whatever news has been shown to us. So in that case, don't you think that they are also committing offense against the public by doing such kind of false, media trial? You don't think that they should deserve some kind of, serious punishment?
The ones who are committing media trial.
Yeah. Wrongful committing of media trial. Wrongful.
Yes, ma'am. That is what I have suggested in my paper, that there is the need of the hour to enact a legislation which will keep a track of wrongfully committing media trial. Because many people, or we only talk about the celebrities and their person, but local people, even the normal people who have also faced such a incident, we don't know about them yet.
Okay, Debasmita, just tell me one thing. While doing research, have you gone through any other country laws where they have prepared any legislation for this, for media trial, all those things? Have you
No,
gone
ma'am.
through any?
I have only confined my paper to India.
But you must do it because as for now, we don't have such kind of provision.
ma'am.
So in that case, you must go for a comparative study where you can see that whether in other countries, how they tackle such kind of issues related to media. You must do comparative study for your research in particularly for this, for this issue.
Yes, ma'am.
Yeah.
Thank you, ma'am.
Nice presentation. Can you hear me?
Yes,
Yeah,
ma'am.
yeah.
I have a question for you. Debashita, to what extent do you think that media has been successful in shaping young Indian minds? And another question is how to curb the present media from turning into an unruly horse sometimes. So how to restrain it without at the same time curtailing upon their freedom, their right to freedom of expression?
Ma'am, the first question I think is by shaping the young minds is today is the generation of modernization, and whatever we hear in news, it is already posted in social media or whatever, or even Twitter handles. So whatever is posted or whatever is written by the news channels, which we take it as authentic channels, then whatever they say, the youth and our generation especially, they work in that direction only. They follow that path or their favorite news anchor. So that is the way I can say they have a vital role in shaping young minds.
But that is leading to a lot of negativities also. Don't you think so?
Yes, ma'am. That is also one of the drawbacks that I have mentioned here. And that is only my focus area that I have mentioned in the paper. So I am saying, in my opinion, I am saying that we all consider media houses to be authentic. Whatever they say is right. So that there needs to be a legislation which controls that whatever fake news or paid news we see, that there should be a control on that.
All right.
Thank you so much, ma'am. Now, I would like to welcome HR Lal Raman Gakhi, research scholar. The title of paper is The Law of Sedition and the Freedom of the Press, a study on the need for media plurality in exercising freedom of speech and expression in India.
Thank you so much, ma'am. Can you hear me now?
Yeah. You're audible.
Thank you, ma'am. So to give a brief overview of my paper, it critically assesses how sedition laws, if they are not carefully defined and applied, it can be misused as tools of repression, leading to stifling dissent and curbing press freedom. So this research, it underscores the importance of upholding democratic values while addressing legitimate concerns relating to sedition and media responsibility, taking into account, especially the account of media diversity and media plurality. So by fostering media plurality, a democratic nation can strengthen public trust and engagement, bolstering democratic principles and safeguarding national security interests without compromising the essential value of freedom of expression. So when we look at the law of sedition in India, if we remember the law of if we know the law of sedition, one of the most cases are our freedom fighters like Mahatma Gandhi and Bal Gangadhar Tilak, who were charged under sedition, and they even pled guilty for the sake of the nation. And since the first case of Jogendra Chandra Bose and all these Mahatma Gandhi and Bal Gangadhar Tilak's case, one of the challenges of applying Section 124 in the IPC is to determine the speech or representation, whether it constitutes to disaffection. So a broad interpretation of this provision could include any negative critique towards the government and its policies and actions, which could be undesirable and counterproductive for a democratic society. And one of the leading cases, one of the most important cases when it comes to the law of sedition is Kedarnath Singh versus State of Bihar, where the Supreme Court held incitement to violence, tendency to create disorder or disturbance of public. So, and recently we know Asim Trivedi, the cartoonist who was also charged under sedition, which was drawn in connection with the anti-corruption by movement started by Anna Hazare. So it was contended that this loyalty to the government established by law is not the same thing as commenting in strong terms upon the measures or acts of the government. So even if the language is strong, as long as it does not incite violence, it does not amount to sedition. That was what the court had reiterated. And when it comes to freedom of speech and expression, we know that Article 19(1)(a) talks about the freedom of speech and expression. So it has been held in the case of People's Union for Civil Liberties versus Union of India that a citizen can express his opinion even in the electoral system by participating and voting for a candidate, that people can know about the people that they are going to vote for their candidates. And even religious tolerance is also under freedom of speech and expression, as we know in the Biju Emmanuel versus State of Karnataka case. And with the advancement of technology and globalization, we have also seen the internet in imparting freedom of speech and expression. And this innovation came with the rise of the internet.
Your 3 minutes are over. We are left with 2 minutes.
Okay, ma'am. So the change of societal values adding to globalization and social media, decency morality has also seen a transition when it comes to even commenting on social media platforms regarding, let's say, early sex or something. Like, it has always taken that regard. And even that woman, as Khushbu, that was her name, she was also taken in under sedition because of that. And when it comes to freedom of the press, so free press is imperative in a democracy, not only because of its intrinsic value and importance in part of an information industry in a country. It also constitutes part of the governmental correctiveness and public vigilance apparatus of the country. And diversity in the media has also been explained in the Ministry of Information and Broadcasting versus Cricket Association of Bengal and Nandar, where it says that the implicit command of Article 19(1)(a) is essential, and it is to promote and preserve plurality and diversity of the views and opinions through media. So the significance of media plurality has also been highlighted in the Telecom Regulatory Authority of India in their report and recommendation, saying that the public has the right to know the unvarnished truth, and every individual has his freedom to have his own opinions based on different views. Hence, the media diversity is really, really important and integral as part of the freedom of the press that they have. And to conclude, I'll say that a critical aspect of media's role in a democratic society is through media plurality, or as I've said, media diversity, which hinges on diverse viewpoints in safeguarding against concentration of media single ownership and influence. So the multiplicity of voices ensures a well-informed populace capable of making recent decisions, which reinforce democratic principles. And but also the regulation and the balance between freedom of speech and expression and the press is also, as I've said, sedition. So the law of sedition also holds that balance between abuse of the freedom that you have been given, even through social media. Thank you so much.
Yeah, I had a question to you. Whether you are in the favor of this keeping sedition law in IPC or not?
Ma'am, I am in favor but it was repealed. But yes, I am in favor of it being retained, but maybe with more, to be amended with more guidelines and strict procedures of arrest, because it has not been mentioned that the procedure of arrest and any arresting authority. It was also noted by the 279 Law Commission report that one of the misuses of the law of sedition is the interpretation of the police officers. So the mode of procedure has not been explicitly mentioned, which causes the confusion. But if that guidelines are issued, and if there's a strict and narrow interpretation, because again, criminal law, it is supposed to be interpreted in its most narrow sense, not open to ambiguity or interpretation. So if there's a strict and narrow interpretation that could be given to the offense of sedition, what it entails, then I feel like it should be retained within the Indian Penal Code.
Yeah, thank you.
Thank you, ma'am. Moving to next, our participant is Neelam Faizan, research scholar, title of paper, The Need to Define Fake News in India, A Call to Action. Ma'am, over to you.
Am I audible?
Yes. Yeah, you're audible.
Yes, ma'am.
Yeah. Esteemed resource persons and co-participants, a very good evening. My name is Neelam Faizan, and the title of my paper is The Need to Define Fake News in India, A Call to Action. So we know nowadays fake news has become the buzzword, although there is no existing literature wherein this term has been rightly accommodated. And with respect to India, this paper has tried to attempt the conceptual understanding of fake news and highlighted various types of information disorder. And it also highlighted the serious issue of not having a proper definition that needs to be addressed via providing an appropriate definition. So at present, fake news is disseminated by all forms of media, be it print, broadcast, or social. And fake news poses a challenge to lawmakers with respect to handling this growing menace, wherein it is easily generated and quickly reaches a larger audience within a very short span of time. Another major challenge associated with this phenomena is what type of content will be categorized as fake news. So with regard to the meaning of fake news, it is very difficult to come up with a single definition, as there is no universal agreement as to where the problem is and how to approach it. Moreover, there is a debate over the use of the term itself. Many scholars have suggested that instead of fake news, the term fake content must be used. If we will look at the dictionary meaning, then the Oxford Advanced Learners Dictionary defines fake news as false reports of events written and read on websites. So it has only taken websites into consideration. On the other hand, Merriam-Webster Dictionary does not give any definition of fake news, though it defines the term disinformation. The European Commission defines fake news as intentional disinformation spread via online social platforms, broadcast news media, or traditional print. If we will talk about countries, then Malaysia has tried to define fake news under Section 2 of its Anti-Fake News Act 2018 as including any news, information, data, and reports which is or are wholly or partly false, whether in the form of features, visuals, or audio recordings, or in any other form capable of suggesting words or ideas. So there are various types of information disorders. And even the term fake news is used interchangeably with the terms misinformation and disinformation. On one hand, misinformation is used to refer misleading information which is created or disseminated without manipulative or malicious intent. On the other hand, disinformation is used to refer to deliberate attempt to confuse or manipulate people through delivering dishonest information to them. So I have tried to cover various types of information disorder, like satire and parody are there, clickbait content, misleading content, false content, fabricated content, sloppy news content, deep fakes. These are all various types of information disorder. And what they all have in common is that how it takes the look of a real news from the appearance of website to the distortion of images. However, the term fake news is insufficient to cover all types of information disorders, because majority of these—
Ma'am, your 3 minutes are over.
The majority of this information is not really fake. In fact, most of the time it is real, but is being used out of context and weaponized by people. Like satire cannot be categorized under fake news because its intent is not to harm people, but to feel people, or it is for a sense of entertainment. I've also tried to cover various working phenomena of fake news by highlighting the concepts of confirmation bias and filter bubble, which here I will not go into detail because of paucity of time. I've given various possible solutions to tackle the problem of fake news. First can be to come up with the fact-checking website, which means the government should come up with this initiative. Then second is through need of the hour is to have a separate law in India to deal with the dangers of fake news. Indirectly, we can say, yes, IPC is there, IT Act is there, or there are various regulatory bodies like News Broadcasters Association, Press Council of India, and IT Rules 2021 also came into existence, but these are all not that much effective to deal with the menace of fake news. Then third, a balanced approach is required in suppressing fake news, as Article 19(1)(a) guarantees freedom of speech. Moreover, our policymakers will need to overcome the definitional and conceptual challenges involved with fake news before drafting legislation to combat it. Fourth, the journalists are required to be more professional and adhere to journalistic ethics. Fifth can be the audiences should understand that whatever they watch and read is not true. They shouldn't blindly forward every piece of information, as mindless forwarding of messages also leads to fake news. and awareness needs to be created in this regard. Then sixth can be that educational institutions must also take the responsibility of creating awareness by educating people on how to be an informed consumer of online information and how to differentiate between real and fake news on various parameters like source of information, bias, style of writing, etc. So I conclude on the basis of my legal research that there is no statutory definition of fake news, and the available definitions are very broad, and it is very difficult to come up with a solution if there is this much ambiguity around the concept of fake news. So technologists, lawyers, and academicians must come forward and try to give a definition that is neither too broad nor too narrow to cover various types of information disorder. Also, all kinds of fake content.
Your 5 minutes are over.
Okay, so just I'm concluding that not all kinds of fake contents warrants attention. Instead, those which are disseminated with commercial or political motives must be looked at more seriously to address this problem. Thank you so much.
Thank you, ma'am.
Yeah, Neelam, actually, you have well explained your presentation, and you have nicely highlighted the issue also. Actually, there is a need of, definition of fake news, and also there is a need of law to deal such kind of issue. It's not only about the fake news, it's also about the media trial, everything related to media. If media, spread, with the help of the media, if someone is spreading fake news, if someone is creating nuisance in the society with the help of this media, then the media or the person behind them, they must get the punishment.
Right, ma'am. Ma'am, there are countries like Malaysia, Singapore, they have come up with anti-fake news laws, and for various type, they have made categories where, ma'am, penalties are also there and imprisonment is also there. But in India, indirectly, also we don't have as such enough laws, and directly, though we know that we don't have.
Actually, we need such kind of laws here also. Yeah, you have done really well in your presentation. Yeah, good.
Thank you so much, ma'am. Thank you.
Thank you so much, ma'am.
Very well structured presentation, Neelam. I congratulate you for it. Neelam, you just cited about various legal systems wherein they have, come up with laws to curb this fake news. So to what extent they have been successful in, curbing this menace? And if we apply such laws in India, so will it be, a successful idea, or can we be successful in implementing those in our countries as well?
Thank you, ma'am. The first point is even I have not gone into that much detail as to how much they have been successful, because there are various political factors also which are playing role. Like in Malaysia, they have passed the law, but with the change of the government, they had to repeal that act. So various political factors are also there. So we have to actually see how they will be effective in future, because even it's very recent initiative from their side that they have come up with these laws. And with regard to the liabilities of the social media intermediaries also, they have proposed, but as such means they have not been followed that much. So it has to be seen actually that how far they will be effective.
Thank you so much, Neelam.
Thank you so much, ma'am. Moving to next, our next participant is Dolly Chaudhary, student. Title of paper, The Watchdog of the Public Affairs, Media Laws, Its Emerging Trends and Issues.
Good evening, everyone. Can you hear me, ma'am?
Yeah, you're audible. Please.
Yes. So I am Dolly Chaudhary, first year student of PG Department of Law. So my title of the paper is The Watchdog of the Public Affairs, that is the media law. So as you all know, media laws and regulations protect all aspects of media, from media practitioners like broadcasters, editors, writers, and producers to media consumers. There is a relationship between media laws and the quality of information. Media restrictions in a topic like censorship and limitations can negatively impact media quality and impose a sense of fear. The media laws impose restrictions on topics such as libel, defamation, censorship, oppressive content, privacy breaches, and copyright. The effect media laws have on press quality depends on the extent of the restrictions, especially the censorship restrictions. In cases with many censorship restrictions, the quality and freedom of the press could be hindered. New media has affected laws and regulations in many aspects, including the effect on social media, on like courts, court sessions, procedures, judicial regulations, and zero conducts. Then the journalists, editors, writers, and broadcasters are legally obligated to follow media laws when practicing their professions, which can be sued or punished accordingly. And better illustration can be given that how a simple information can be rumor or a made-up story about something can be notably damaged and harmful to the society, and not only to the society, to the world. That is the example of the COVID-19 pandemic, which we all know. Coming to my first objective of my paper is to respond to questions about how reliable new media is on global scale and in the digital medium. So the advancement of data in a clever domain and a new area of media is how new media is defined and distinguished. It is frequently believed that this sector applies and controls existing media regulations with greater rigor. As a result, the internet and web-based entertainment, that is the social media, constitutes the current new media. So the effect of new media can be clearly illustrated, as I have mentioned in my paper, a case law, that is the Her Majesty's Attorney General versus Kasim Dave and Joseph Beard. Then the second objective of my paper that has mentioned about the investigation, which is extended its contextual assessment to countries like US, France, and China. The coming to the assessment of different countries in US has adopted the Freedom of Information Act so that the people got the information what is going in the government. Then there is the Privacy Act of 1974, which is another resolution about the development of data in the United States. Even though France has a few restrictions and press limitations today, the right to freedom of the press is a guaranteed right there, but not in most of the cases. In terms of history and media restrictions,
ma'am, your 3 minutes are over.
Okay, ma'am. China has the most hints of limitations. China's restrictions principles might be compared to those of countries like France and USA. Then the last objective, that is how the media portrayals are prosecuted online and in their most recent forms. The best example I want to give is that Section 66A of the IT Act. Section 66A is being challenged because it violates people's freedom of speech and articulation. Recently, the Supreme Court ordered states and their police forces to stop prosecuting free speech on social media under Section 66A of the IT Act, which was struck down as unconstitutional in the Shreya Singhal case. I want to conclude, media restrictions are not the same across the world. Some nations prioritize and constitutionalize freedom of the press, which others impose heavier press limitations, depending on their state's economic, social, and political status. Government have established the importance of the press and media in its traditional and new form. They have since adopted and acknowledged strategies and rules to better tend to the industry and establish guidelines to recognize new media as a reliable and well-protected media source. Thank you, ma'am.
Yeah, Dolly, you have presented very well your research paper, and I had no question for you. Hina ma'am, you had any question for her? Deepshika ma'am, I think we can call the next presenter.
Sure, ma'am. Thank you so much. Next presenter is Shelly Bag, student. Title of paper, From Individuals to Icons, Navigating Personality Right in the Era of Media.
I would just request Mr. Pradeep Gharami to mute himself. Yeah, we can go ahead with the presentation.
Hello, ma'am. Am I audible?
Mr. Pradeep Gharami. Mr. Pradeep Gharami, please mute yourself. Ms. Shelley, please go ahead with the presentation.
Good evening to everyone present here. I'm Shelly, and today I'm here to present my paper titled From Individuals to Icons, Navigating Personality Rights in the Area of Media Trends. So the presentation plan of my paper is to navigate through personality rights against the backdrop of prevailing media trends such as posthumous publicity, moment marketing, and deepfakes. The issue is that the paper aims to scrutinize how publicity rights functions within the context of contemporary media phenomena, including recent cases of Olympian PV Sindhu, renowned actors such as Amitabh Bachchan, Rajinikanth, and the late actor Sushant Singh Rajput. So let's begin with how personality rights is here in India. So the legal landscape is that the personality.
Sally, I think your voice is not clear. I don't know whether for others, whether Sally's voice is clear to everyone.
Oh, it's very slow.
Yeah,
no, ma'am, it's not clear. It's very slow.
Am I audible?
Yes, still your voice is echoing.
And like this place is like a.
Sally, you can do one thing. You just remove your headphone. Without headphone, you just speak.
Okay.
Try to speak without using a headphone.
Hello.
You're still not audible.
Ms. Shelley, do you have a wired earphone in any case?
Hello, am I audible?
Could you hold your mic closer to your mouth? Could you hold your mic closer to your mouth, please? The mic that is connected to the earphone.
Your voice is actually too low to understand what you are speaking actually.
No, ma'am, your voice is still echoing and it's coming very slow. Ma'am, I would request you to please leave and again join the meeting.
Do one thing, just join from your mobile.
Yeah.
Just join from your mobile, yeah. That will be better.
Hello, ma'am.
Can you please join from your mobile and save the PPT on your mobile? And we will go ahead with the next presentation, and you can make the necessary adjustments and put a text in the chat that you are ready to present, and we'll accordingly call you up. Is it all right?
Ma'am, like, am I not audible right now?
Yeah, right now you're audible. Now it's clear.
Okay, ma'am. So I will just continue with the presentation.
Yes, you may just try to speak a little louder. That will be helpful. Thank you.
So the introduction of paper, I talked about the introduction of paper and the issue. So that the issue of the paper is that it aims to scrutinize how publicity rights functions within the context of contemporary media phenomena, such as the recent cases of PV Sindhu and Amitabh Bachchan and Rajinikanth. And then in the conclusion, we try to take a balanced approach to see if there is a need for specific legislation to protect such emerging new challenges in the industry of media and entertainment. So the personality rights enforcement in India lacks a specific statutory provisions as of now. the personalities can resort to common law tort of passing off and often under trademark law to combat violations of these rights. And this legal recourse requires establishing three elements, that is the celebrity's reputation, misrepresentation of their identity, and the resulting irreparable harm due to passing off. Such an approach reflects a focus on human dignity and liberty rather than treating individuals as mere commodities. So it is important to understand that personality rights arise from the contradicting coexistence of right to publicity and right to privacy. Individuals who thrive in the realm of publicity also possess movements to seek out privacy. There are certain ways which are taken for protecting personality rights, including advertising legislation, that is the Code for Self-Regulation in Advertising, and the right to privacy under Article 21, and existing IPR laws. So let's look into how personality rights intersect with other cases. So the media exploitation of personality rights started with several famous cases such as the Titus Industries versus Rajkumar Jewellers. In that, the Delhi High Court said that a celebrity is characterized as a renowned or widely recognized individual, someone who is extensively discussed or familiar to numerous people. The court stated that the key components constituting liability in cases of such personality rights infringements are: first is validity, that signifies that the celebrity holds an enforceable right over the identity or persona of a human being. And second is identifiability, which involves methods to ascertain the celebrity's identity. The court, while acknowledging the personality rights of Amitabh Bachchan and Jaya Bachchan, issued an injunction against the defendants who had displayed an advertisement featuring images of the celebrity couple without obtaining their consent. Then the question arises, can media misrepresentation be done without any involvement of the celebrity's image? For that, there was another case of Shivaji Rao Gaikwad versus Varsha Production, in which the renowned actor Rajinikanth filed a suit against Varsha Production and sought an injunction to prevent the defendant from utilizing his name, characteristics, dialogue delivery, and etc. in their upcoming film, alleging that it infringed upon his personality rights without consent and tarnished his reputation. The court in that case granted the injunction, citing Article 21 of the Constitution, which upholds the individual's right of a dignified life. This case shows how legal protection accorded to a person's reputation and personality style in the context of media representation is important for the person to not get commercially exploited from the act of mimicry. Now, the next issue that I'm going to talk about.
Ma'am, your 3 minutes are over.
Okay, about moment marketing. It is like a
Shall
concept that involves
come to your concluding part. Shall we come to your concluding part?
Okay. So, I talk about the moment marketing and the unsettling legality of deepfakes, where there is no concrete solution for the existing problem right now. With lack of specific legislation, people are resorting to IT Act to recognize its existence, which isn't much effective. So, with its pool of diverse talents, India is well positioned to benefit from a legal framework that not only safeguards personality rights but also drives economic growth. The paper examined the state of such rights in India and highlighted the legal gaps that exist when we look at the current media trends, such as moment marketing and deepfakes. By proposing a creation of a comprehensive legislation inspired by other nations, such as US and Canada, India could establish a clear structure for the protection of and commercialization of such rights.
Yeah, thank you, Shelly. Deepsika, I have no question for Shelly.
Okay, ma'am. Thank you. Moving to next, our next participant is Preetam Subba, research scholar, judicial. Title of the paper is Judicial Approach Towards Misuse of Pardoning Powers.
Good evening,
Over to you, sir.
Am I audible, ma'am?
Yeah, you're audible.
You're audible, sir.
Good evening, all. My title is The Judicial Approach Towards the Misuse of Pardoning Power, Pardoning power is, I believe, one of the most important aspects or powers that has been is there under the in our Indian Constitution. The power lies with the president at the central level and with the governor at the state level. The power is there under respectively under Article 72 for the president and Article 161 for the governor. But we'll have to look into this power because Article 72 and 161 cannot be read in a standalone manner. It has to be read in the light of Article 74 and Article 163, which states that this power can be exercised only with aid and advice of the Council of Ministers. Now comes the concept of judicial review. Judicial review has been declared to be a part of a basic structure of a constitution in various decisions of the Supreme Court. And now what has happened is that, as I said, that Article 72 and Article 161 that deals with the pardoning power has to be read with Article 74 and 163. So generally, in most of the cases, what is happening is that it is actually not the power that is being exercised by the president and the governor, but it is exercised by the Council of Ministers. And who are the Council of Ministers? They are the party in power, either at the center or at the state. So there is a good chance that these powers can be utilized for political consideration. And there have been many instances regarding the same of it being used for political consideration rather than for the administration of justice. Now, when we talk about the judicial review, the court definitely has the power to look into various aspects or misdeeds that can be done. And if you look into the definition of judicial review, it is to basically re-examine that has been done either judicially or administratively by the higher courts or the appellate courts. But what has happened is that there is a provision under Article 74, Clause 2, and under Article 163, Clause 3, which states that whatever advice has been tendered by the Council of Ministers, it does not come within the purview of judicial review, or it cannot be looked into by the court, as a matter of fact. So what has this done is that this has given a very good blanket kind of a coverage to the, let's say, the advice, aids and advice that the government, the concerned governments can give. And in the light of such a protection that has been afforded by the Constitution itself, there might be some political consideration. And the court has been, after independence, after our Constitution came into being, the court has been very reluctant in touching or looking into the concept of pardoning power by the way of judicial review. In fact, in several cases, and especially in the very earlier case related to pardoning power, judicial review of pardoning power, in the case of Krishna Gaud, it was basically said by the court, by the apex court, that is the Supreme Court, has said that since these powers are given to the president and the governor with the belief that they will be exercising it in a bona fide manner, so there is no doubt that they will not be exercised in a bona fide manner. So the court said that we will not look into the fact whether it has been done in a bona fide manner or not, because they believe that it will be done so. But what has happened is that if you look into the judicial review of the pardoning power, it can be divided into two phases. One phase is known as pre-Maruram case, and another one is post-Maruram case. The Maruram case was decided in the year 1980. Maruram versus the state. Maruram versus the state of Punjab in 1980. What had happened was that this was the first case in which the Supreme Court looked in depth regarding the pardoning power, the concept of pardoning power, and whether the pardoning power can in fact be judicially reviewed or not by the court. So what the court did was
your 3 minutes are over.
Thank you, ma'am. What the court has informed is that what the court decided was that definitely the pardoning power can be reviewed, but only on certain specific grounds. They cannot be a blanket kind of a generalized kind of a review of a pardoning power of the president, but only in cases where there are this specific provisions, or the specific doubts whether it has been exercised arbitrarily without use of mind, or for some kind of an in a manner that is not has not been permitted by the Constitution, then the judicial review of the same can be done. But once again, can be done in a very limited way. Now, what has happened is that this decision has found support in later on in Kehar Singh case also, and various other cases also. But in all of these cases, it is to be noted that the judiciary has said that it has to be confined to certain specific grounds only. It cannot be done as general matter of rule as a judicial review. So this, some of the leading cases that has led after the Maruram, some of the leading cases in which the judicial review of the pardoning power of the president and especially the governors were in the cases of Sarwan Singh, Satpal, Narayan Dutt, Irupu Sudhakar, and Shatrughan Chauhan case, which were very much related to the misuse of the power by the governors of the state. There are very few instances where the president has been questioned regarding the misuse, but the governors of the state has again and again been found to misuse the power or pardoning power for some political gains and all. So I'd like to conclude by saying that the judicial review is a very important concept for to creating a balance and checks for such a wide power that is given to the president and the governor. And my belief is that it has to be expanded to all the cases of mercy petitions, whether it is accepted or rejected, where prima facie there appears to be bias, arbitrariness, or lack of application of mind in making such decisions. Okay, thank you.
Thank you, Preetham, for your well-presented research paper. And actually, the thing, whatever you have suggested and highlighted in your research, that is actually issues relating to, judicial process also, you can say about the executive process also. The issue which it is, that is a judicial as well as executive issue in that scenario. And relating to pardoning power, and we have seen many, cases also where actually there was a need of, giving pardon to the accused person or the other person. But because of our system, you can say that he or she has not get that. And there are other cases also where they're not supposed to get the pardon, but they have get it. So there is a dicey situation relating to pardoning power, and whatever you have highlighted, I really like that and appreciate that. And I hope that whatever you have suggested, suggestion you have given in your research paper, if that can be accepted, or if government take that note while pardoning, for giving this pardon, all those things, I think that will be beneficial for judiciary, executive, as well as for the society also.
Thank you, ma'am. Thank you, ma'am.
Thank you, ma'am. Moving to our next participant, Abhilasha Mahanta, student. Topic of paper is Judicial Review and Judicial Accountability, Striking a Balance in Modern Legal System. Abhilasha Mahanta.
Yes, ma'am.
Yeah,
Am
over
I
to you.
audible?
Yeah, you are audible.
Good afternoon, ma'am. A warm welcome to all the dignitaries present here. Myself, Abhilasha Mahanta, and I am the LLM second year student from Guwahati University. The title of my paper is Judicial Review and Judicial Accountability, Striking a Balance in Modern Legal System. In the meaning of judicial review, it means that court power to review the actions of other branches of government, especially the court power to invalidate the legislature and the executive action as being unconstitutional. It means that it is the power of judiciary to examine the constitutionality of legislative enactment and the executive order of both the central and the state legislature. Broadly speaking, the meaning of the judicial review, it means that it means judicial review of legislative action, judicial review of administrative action, and judicial review in the judicial decision, etc. But the importance of judicial review to uphold the principle of supremacy of the Constitution, to maintain the federal equilibrium and protect the fundamental rights of the individual. But on the other hand, the word accountability is defined under the Oxford Dictionary means responsible for your own decision and action. And expected to explain them when they ask. Accountability is thank you for democracy, transparency facilitate the accountability. But the on the other hand, accountability of the judiciary in respect of its judicial function in order to provision for appeal, revision, and review of order for the process of impeachment, where under the 2/3 of the member of each House of Parliament can vote for the removal of judge. It is an example of judicial accountability. The need for judicial accountability is that the power and position in a democracy is displayed by the with their own responsibility, and every discipline of the public office must remain constantly accountable to the people, who are accountable to their political sovereignty. In the need of deficiency is they make judiciary accountable. The value of judiciary for damages in the government, as judiciary has acted as a guardian of our own constitution. But the main point on the our topic is the balance between judicial review and judicial accountability in modern legal system. It is that in modern legal system, judicial review and judicial accountability work together. Judicial review allows the court to examine the action of the government and other institutions to ensure within their bound and with law and constitution. In the same time, judicial accountability ensures that judges themselves are held responsible for their decision and conduct, maintaining the integrity and fairness of the judicial system. So the balance between the judicial review and judicial accountability is most necessary. On the other hand, judicial review focus on the oversight of the government action, their laws, while the judicial accountability focus on ensuring ethical standards and their accountable for their own behavior. On the other hand,
your 3 minutes are over.
To review and potentially laws on action and unconstitutional on inconsistent with the legal framework. It helps them maintain a balance between power and ensure the protection of individual rights. But on the other hand, judicial accountability is equally crucial to maintain public trust in the judiciary. Both concepts are together ensure the just and fair legal system. Okay, ma'am. Thank you, ma'am.
Thank you very much. Ma'am, would you like to ask any question? Okay, ma'am. Moving further, our next participant is Elizabeth P. Mathai. She's a student. Title of her paper is Judicial Accountability, Issues and Challenges in Modern Era.
Good evening, everyone. Am I audible to everyone?
Yes, you're audible.
Okay, ma'am. Can I share?
Proceed. Yeah, sure.
Okay, ma'am. Thank you. So my topic for the presentation is judicial accountability, issues and challenges in modern era. And my paper is based on, and the abstract is about going into deep into the judicial accountabilities, complexities, and the importance of striking the right balance between the judicial independence and accountability. And it also explores the obstacles to effective judicial accountability, such as unclear mechanisms to address misconduct and a lack of external oversight. It emphasizes the need for a comprehensive approach rooted in transparency and ethical conduct to ensure a functional and trustworthy judiciary. The role of public scrutiny and media coverage in promoting transparency is also discussed in my paper. So before we go into the delicate balance between the judicial independence and accountability, we have to know about what is judicial independence. It is encompassed in the concept of separation of powers, as the judiciary is independent from the legislative and executive interference, and the impartiality of judicial decisions, which safeguards the judiciary from undue influence or control by the executive or legislative branches. This is a fundamental principle of democracy in virtually every democratic nation, and it is seen as a system of checks and balances with the legislative responsible for creating laws, the executive for executing them, and the judiciary for scrutinizing their legality. The Indian Constitution provides provisions under Article 50 to ensure the autonomy of each branch and to restrict any unfair use of power. And about judicial accountability, It is a cornerstone of a well-functioning democracy and a rule of law. It requires judges to be accountable to the proceedings they are initiating and to uphold their public trust and fairness in India. Several legislations are there, like Judges Inquiry Act 1968, Contempt of Courts Act 1976, and Judicial Standards and Accountability Act 2010, and the Right to Information Act 2005. So we will move on to the delicate balance and the perceived conflict between the judicial independence and accountability in the Indian context is not a contradiction, but a tension between the approaches used to promote each. It is essential to strike a balance between these two principles. As we have understood, judicial independence is a complete independence of judges, and the judicial accountability is that they are accountable to the public for their actions they are doing. So these two are integrated. These two should be in an integration or in a fraternity. And because ensuring the right individuals are appointed to the bench is the most critical factor in creating an independent and accountable judiciary. The balance between independence and accountability will vary in each society based on the demonstrated levels of courage and integrity among judges. This perspective underscores the need for a rigorous and merit-based judicial selection process and an ongoing evaluation of judges' performance. Challenges for judicial accountability in India stem from the delicate balance between independence and accountability, which can impact the credibility of the judiciary and impede the upholding of constitutional values and citizens' rights. And there are lots of challenges to this judicial accountability, which is a lack of a transparent mechanism. The absence of transparent mechanism for addressing complaint against judges. We know that a common man in India will not be aware about any actions which could be taken against judges, and the limited external oversight. As I have already said, there is a separation of powers, and judiciary is judges and judiciary.
3 minutes are over.
Okay, ma'am.
You're left with 2 minutes.
Okay, ma'am. Thank you, ma'am. Okay, there are limited external oversight only, which shows that judges are seen as above being above scrutiny. That is, they are having complete independence, and they are having limited external oversight. Next one is political interference concerns and potential compromise of accountability due to the executive judiciary interplay and the fear of political interference in judges' appointments, hindrance to holding the governments accountable and all, and the delayed proceedings. In the judiciary, we know that most of the proceedings are very lengthy, and the common men are not able to go for such a long proceeding. Every month they have to go to the judiciary for doing the stuff and all. So that is one of the challenge, and the lack of uniform standards, absence of uniform standards for judging judicial behavior and misconduct, subjective evaluation of judges' actions, room for interpretation and inconsistency in accountability decisions. And then my next topic is impact of public scrutiny and media in holding judges accountable. The public scrutiny, often driven by the investigative journalism, helps uncover judicial misconduct and corruption. The media can expose high-profile cases and lead to disciplinary actions against judges. This fosters trust in judicial system by demonstrating its commitment to delivering justice fairly. But it too have a challenge because this media, exposure of media in the judicial system can influence the public opinion unfairly. They can defame, they are able to defame the judges also. Judges will be so much accountable that that means they will have an influence. They will be influenced by the media itself because they will be having a fear of this.
Ma'am, your 5 minutes are over.
Okay, ma'am, I will go to the conclusion. And okay, as a conclusion, I'm saying that this my article deals with the delicate balance between judicial independence and accountability in modern democracies, and it contains challenges. And the only solution for this is the integration of this judicial independence and accountability. And that's all about my topic. Thank you.
Thank you, ma'am. Ma'am, any questions?
No, ma'am.
Thank you, ma'am.
Okay, moving further. Our next participant is Kovuri Tarun Ganesh Reddy, student, Title of paper is Judicial Review, a comprehensive analysis with critical concern and potential solution.
Good afternoon, everyone. I'm Tarun. My topic is about judicial review, its limitations and the solutions for the limitations. The Indian judiciary is empowered to judicial review by Constitution of India. The judicial review is one of the checks and balances in separation of powers. It is the power of judiciary to supervise the legislative and executive branches and ensure constitutional supremacy in all the three branches. In India, there are many case laws which the judiciary has dealt with that fills the gap or vacuum that has been created by the legislative or executive. Some of those cases are P. Ramchandra Rao versus state of Karnataka, Vishaka versus state of Rajasthan, and Ardul Shah versus state of Bihar. And in those cases, primarily it is said that judiciary can only remove or add words only when the Constitution of India has been violated, or constitutional provisions of India has been violated. Now moving on to the limitations in judicial review. The first limitation, in my opinion, is excessive reach of judiciary or judicial overreach. If the legislative has been intervened by the judiciary over and over in the time, the public or India will lose trust in the government. So the judiciary should not overreach, and to overcome this, the laws may be clearer and judicial reforms should be made so that only judiciary comes into play only when the constitutional provisions are violated. Another limitations of judicial review is political pressure. This might not be on the paper, but in real life, the judges who are dealing with judicial review, the political parties bring pressure or excessive pressure on the judges to resolve the case in favor of the government. And I agree that in the separation of power, judiciary has its own powers and will not be under any other branch. So to overcome this, in my opinion, the courts or tribunals should be made that deal only exclusively with the judicial review, so that the other cases pressure will not be on the judiciary. Along with that, the supreme power of judiciary can also be implemented. And the last thing of our solution that can be applied to all the judicial review cases is training and education of judges and lawyers. In this modern era and the growing society, legislative is trying to bring new laws that match the society. The judicial review or the judges or the lawyers should be well aware of the changes that are going on in the society, so that they can intervene or interpret the statutes brought by the legislative very clearly. Thank you, ma'am. This is the presentation.
So, ma'am, would you like to question?
No, ma'am, no question.
Okay. Now moving to our last participant, Kathuri Nikhil Kumar, student. Title of the paper is Judicial Activism in India.
Yes, ma'am. Good evening, ma'am. Am I audible, ma'am?
Yeah, you are audible.
Yeah, you are audible.
Yeah, my title of the paper is Judicial Activism in India, ma'am. So before moving into the evolution of the judicial activism in India, first let us know the meaning of judicial activism. So as one of the organs of the state, the judiciary plays an important role in promoting or upholding the citizens' rights in our country. And also it signifies, mainly the judicial activism signifies the overstepping into the executive. So then the concept of public interest litigation is talked whenever the judicial activism is discussed. And also Justice P.N. Bhagwati and Justice V.R. Krishna Iyer achieved success in liberalizing access to justice by applying the principle of judicial activism. And of course, the concept of judicial activism is opposed to the idea of judicial restraint. But both these terms are frequently used. I mean, to describe the what we say, the assertiveness of judicial power, and etc. So, speaking about the evolution of judicial activism, it is the one of the finest cases that a person named Sunil Batra is one of the prisoner in Delhi. I mean, what happened to is I mean, he was physically abused continuously without any reason. So he had no way out of it. Then an idea struck into his mind is he wrote a letter to the Chief Justice of Supreme Court that though I may be a prisoner, but it doesn't mean that my dignity may be curtailed. So please help me out in this regard. So he requested the Chief Justice of the Supreme Court. So please help me out in this issue. So this is the first instance, or this is one of the instances where judicial activism was evolved. I mean, this is one of the finest cases where judicial activism was evolved. So this is with regard to the evolution of judicial activism. So and also there are many cases related to judicial activism like ADM Jabalpur, Shivakant Shukla case and AK Gopalan case. So there are many of the cases. I mean, we can categorize the judicial activism into 3 stages, such as from period, depending upon the period years wise, like 1950 to 1970, 1970 to 2000. But of course, the judicial activism began in the late 1970s through the Sunil Batra case. I mean, the period in which judiciary and judges established the concept of judicial activism, and also it gained popularity. But from 2002 till now, judicial activism it has flourished and it had touched various aspects. And also now the Supreme Court, by exercising the judicial activism, is interfering in the various aspects, such as it is interfering in the aspects of government, and also it is interfering in the aspects of administration and what so on. So this is the era now. And also there are various methods of judicial activism which are followed in India. One of the method is judicial review, and also filing a bill, public interest litigation, and also the constitutional interpretation, and so on. So then moving on to the criticism of the judicial activism. Judicial activism, it has been also...
Sir, your 3 minutes are over.
Yes, ma'am. Then judicial activism also mean criticized many times. So, and also by the namesake of judicial activism, it mixes with the personal opinions of judges with the law. And also the second criticism is the theory of separation of powers between the 3 organs of state with judicial activism. I mean, it happened many times in India in the name of activism, where it interferes with the executive domains. This is the criticism. So with this, I conclude that, and my opinion with regard to judicial activism is, it must be, and it must be used as a weapon for a judge. It is a weapon for a judge while he interprets any law and finds it is unclear and it is ambiguity in implementing that one. So and also while exercising judicial activism, he must ensure that no partiality, he must not be partial towards any party. This is my opinion. And also, while the intention of the legislature behind incorporating any provisions of the statute, the legislature may not confine every issue while legislating a particular regulation. Then the judges, through this judicial activism, may come up with a new one, such as we observed rightly in the Sunil Batra case. If any rights of the citizens are abridged and violated, then the court, through the power of judicial activism, it may come up with a solution like that. Yes, ma'am. Thank you, ma'am.
Nikhil,
sir.
what is your take on judicial overreach and how to, strike a balance between, or you draw a line of distinction between judicial activism and judicial overreach?
Actually, judicial activism is a Lakshman Rekha where judges need not cross to some extent. Where it's a Lakshman Rekha where judges cannot reach the line. They are confined to only judiciary, but this judicial activism can also ensure that you can also step into the aspects of the executive and legislature. You can question the the doings of the executive. Hello.
All right. Yes, got your response. Okay.
Okay, sir. Thank you so much. Now I would request our resource person, Dr. Pyali Chatterjee ma'am and Dr. Hina Kaushal ma'am, to please share some insight regarding the session with our participant.
Yeah, thank you, Deepsika ma'am. First of all, they have presented very well and nicely about the research paper. And all of them, they have discussed, every aspect of issues related to media trial, even this judicial activism, related to judiciary, executive thing, everything. So today we have seen that even the some of the students also, they have, nicely presented their paper, and it feels very good, when you see this new generation, the future advocate, when they are presenting and arguing for their research paper. It was really nice to see everyone, those who have presented their paper. You have really done very well, and you have well researched your paper also. And I really want to congratulate some of the, like Nikhil and Subha, I think, Pritam Subha, you all have done, very well. Even Rumi Roy also, you all have done very well about while presenting your research, and you have come forward with a new thing which we also enjoyed while hearing your presentation. So all the best to all of you.
Okay, ma'am. Dr. Hina Kaushal ma'am, would you like to say anything?
Good evening, everyone. First of all, I would like to congratulate all the presenters today who had delivered a very wonderful talk on and touching upon various crucial topics, obviously ranging from judicial review, judicial activism, role of media, and then role of media in igniting young minds, and so on. So it was a wonderful session, having divergent views from across all students and faculty members. I enjoyed the session a lot and got a lot of insights from this session. I would also like to thank Dr. Pyali Chatterjee ma'am and the organizers of this entire event for giving me this opportunity to be present here and be the resource person for this session. Thank you so much, and all the best to all the presenters for their future work, future research work. Thank you.
Thank you,
Thank you, ma'am. By this, we end this session, and thank you, everyone. Thank you, all the participants, for your valuable time. Thank you, ma'am. Thank you so much.
Yeah.
Thank you, ma'am. Thank you.
Thank you, ma'am.